Someone make it make sense.
Probably a couple.
Hello, squirrel people of the world. Welcome back to another live stream. Hope y'all are doing well. So the insanity continues, and the limit does not exist, as was in the thumbnail. So we are going to jump right on in. So we've been going in chronological order. For anyone who's new, there's a playlist for this case as well as all the other cases that are currently ongoing or that I've already covered. So we are at this juncture. We are in June of 2024, June of this year. So we are here with, so what happens, it looks like on this day, is that the defense for Shanna Gardner, led by Jose Baez, came to the courthouse, delivered a number of filings, and then subsequently had a press conference, which we will watch after we read these filings, which were again filed this day. So June 21st, 2024. So the first, we have defendant's third disclosure to prosecution. So defendant identifies the following witnesses to be called at evidentiary hearings and or trial. 1, Susan Lee. Now, who's Susan Lee? Also known as Sue. Sue, or Susan Lee, right? This is the person who Kimmy, Shanna's friend, had reached out to. Now, this is before Shanna had ever met Mario, okay? Had reached out to, so Shanna asks Kimmy if she can find a person to do away with Jared, essentially, right? Like literally it's solicitation, right? And so Kimmy reaches out to Susan, right? In these text messages, this is what Kimmy says. And that she's got a friend, Susan, who she's going to ask. And Susan apparently can't find anybody. And it's like after this point, that's when later on, Shanna meets Mario and then blah, blah, right? So, but in other words, the state has already kind of alleged and hinted at Kimmy and Sue being co-conspirators. They have called them co-conspirators. However, they've not been charged. So this is who Susan Lee is, okay? And then, here we go. Defendant discloses the following evidence to be used at evidentiary hearings and or trial. Statement of Susan Lee from May 23rd, 2024, and statement of Kim Jensen from June 14th, 2024. Now, why is this significant? Because these statements are new in terms of where we're at in this case at the time. So what this means to me is that they reached out and got the defense must have reached out and been provided statements, unless these were from the prosecution. Now we will find out more because it seems that the prosecution had been working with Kim and with Susan, right? We know at very least there was that crazy interrogation of Kim, but in other words, either these statements were taken by the prosecution and not turned over to the defense, which is a problem, or these were taken by the defense. But either way, these are new statements to us, okay? So that's the first one. Okay, let's move on to the second one. Okay. So defense motion to release defendant on bond. So remember, we covered this last time, how they can ask the judge to reconsider because it was denied, but they can come again. It was denied without prejudice, right? Which means that they can try again. So here we go. So as per usual in this case, we've got all caps, underline, and bold. Defense motion to release defendant on bond to prohibit the state from using certain evidence at trial based on state's failure to disclose favorable evidence and other relief. All right. Comes now Shanna Gardner. Statement of facts. We don't need that. And as far as the first part. So on November 1st, 2023, the defense filed its demand for discovery. Ms. Gardner first appeared before the court on November 3rd. There have been and continue to be logistical issues related to the disclosure of discovery by the state to the defense. Despite this, the state has disclosed enormous amounts of data to the defense. And then blah, blah. The state disclosed certain incriminating statements alleged to have been made by Ms. Gardner in its exhibit. That's in reference to the bond hearing that we already watched. The state informed the defense that many of these statements were contained in Kim Jensen's grand jury testimony. And remember, there was even some confusion even from the judge. This was on the most recent video that we did where they had a hearing and the judge was asking for clarification. Were these text messages or were these grand jury statements or were these other statements, right? Because remember, that crazy interrogation that they had with Kimmy was somehow not recorded. The state agreed to unsealing the testimony and the court issued an order doing so on December 1st, 2023. The state made certain disclosures in its discovery exhibit related to Henry Tenon. The state made no similar disclosures related to Kim Jensen. The defense received Kim Jensen's grand jury testimony on January 22nd, 2024. The prosecutor is present at the grand jury, blah, blah. Upon reviewing the transcript, the defense identified many statements by Kim Jensen that tended to negate the guilt of Ms. Gardner and undermine the credibility of Ms. Jensen as a state witness. This included, for example, that Ms. Jensen told the state that she had a stroke a few years ago and that she, quote, often jumbles timelines and facts, and sometimes it's hard for her to remember. This was in addition to the repeated assertions that neither she nor Ms. Gardner had knowledge of or involvement in the murder of Jared Bridegan. These statements were never disclosed to the defense pursuant to Florida Rules of Criminal Procedure, though the defense did find them through due diligence. On February 5th, now remember in Florida, they have specific rules of discovery that are reciprocal, right? So they're, in every state, right, they're supposed to always be turning things over. But in Florida, it's even a bigger deal if you don't turn things over. On February 5th, 2024, the defense filed a motion to set bond. On February 15th, the defense filed a motion to schedule an evidentiary hearing. We watched all this. So on May 14th in the afternoon, the parties exchanged draft evidence lists. It was after reviewing the state's evidence list that the defense first heard the name Susan Lee. Ruh-roh, so that was not disclosed. Ms. Lee was not listed as a witness on the state's discovery exhibit. The defense also became aware that the state only intended to call Detective Christopher Johns, the lead detective in the case, at the hearing. On May 15th, the court held the Arthur hearing. At the start of the hearing, the defense became aware that the state would be using a PowerPoint to present the testimony of Detective Johns. The PowerPoint included alleged oral statements not memorialized anywhere made by Ms. Gardner to Ms. Jensen, though similar statements were disclosed by the state in its discovery exhibit. The state also admitted several text message strings between Ms. Gardner and Ms. Jensen. The state elicited no testimony regarding Ms. Jensen's prior statements regarding her memory and recall issues or her assertions that Ms. Gardner had no involvement in the case, and, as will be explained below, specific exculpatory statements made in response to the very text messages and alleged oral statements used by the state. During his direct examination, Detective Johns advised the court that he had reviewed text messages between Ms. Jensen and Ms. Lee, wherein the two discussed potential suitors to carry out the murder of Jared Bridegan at Ms. Gardner's discretion. And that's correct. That is what we heard. That is what Detective Johns said. Yep. Referring to State's Composite Exhibit 9, Detective Johns testified on direct that Ms. Jensen had reached out to Ms. Lee to see if Ms. Lee's husband knew of anyone who could carry out the murder. Yep, that's what we heard. When asked if he had ever spoken to Ms. Lee during cross-examination, Detective Johns stated, "I believe one of my colleagues did." However, Detective Johns could not recall which officer and admitted that he had not read a report evidencing that an officer had actually done so. They cite the Arthur hearing. Subsequent thereto, Detective Johns changed course and testified that at the time he tried locating Ms. Lee, her phone number had changed and we didn't have a good address for her, so we were not able to contact her at the time during the messages. While watching the Arthur hearing via internet coverage, Ms. Lee became so outraged by the misrepresentations made by the state. Okay, so remember when I said either that statement was from the defense or the state? It was the defense. Check it out. She became so outraged by the misrepresentations made by the state that she reached out to an attorney who subsequently contacted the defense. This is kind of like we saw similar things with, like, for example, the Karen Reed jurors, other things where they're like, they decided to contact the defense. And of course, this isn't a juror. But similarly, right, where they're like so pissed off at the misrepresentations that they reach out. That's crazy. Ms. Lee provided a statement that confirms she did, in fact, speak with Detective Johns. That she had the same phone number since 2014, and that her exchange with Ms. Jensen was part of a larger ongoing joke regarding racist statements made by a former boss about her African-American husband. Oh boy, there's a lot here. So first of all, this, if it's true, completely refutes what Detective Johns says, and that's a problem, right? That she did speak with her, that she's had the same phone number, and then, according to Kimmy, she's like, those were all jokes. All those text messages were jokes. Remember what I'd been saying before too, guys, that they're kind of in a predicament, right? Because either all of the Kimmy and Shanna text messages are jokes, right? Or they're legitimate, in which case both of them are talking about killing people, like a lot of people, including people that work for Enterprise and other things, their own children, things of that nature, right? So this makes more sense, right? Kimmy's like, these were all jokes. Oh boy. Ms. Jensen was similarly outraged by the unfair portrayal of the text messages and the failure of the state to accurately relay her explanations of the context of the text messages between her and Ms. Gardner as she watched the Arthur hearing online. Wow. She similarly has now retained counsel and reported to the defense that she did not make certain oral statements presented by the state, that certain exculpatory statements were omitted by the state, and that the circumstances of a July 2023 custodial interrogation of her by the state were inaccurately represented. And I'm still wondering, did they ever read her rights? Because like I said, it was clearly custodial. Wow. Ms. Jensen has informed the defense that Detective Johns followed and approached her at the local supermarket. Wow. With at least 3 other members of law enforcement and served her a subpoena without a date on it. Footnote 1. The defense has not yet found this subpoena in discovery. Detective Johns then told Ms. Jensen that he would transport her. So this is the circumstances under which she was interrogated, okay? Transport her to the state attorney's office to comply with the subpoena. Again, that's why this is interesting that they couldn't find this subpoena. So was this all lies? Were they threatening her? I mean, this is insane. This is insane. This is not okay. Oh my God. If they told her there was a subpoena and then they escorted her, oh my God, to an interrogation because she thought there was a subpoena and there wasn't one. There was an exchange after which Detective Johns conceded that he could not detain her. After advising that she would drive herself, Detective Johns and the other law enforcement in 2 vehicles boxed in Ms. Jensen as she drove to the state attorney's office. Upon arrival, Ms. Jensen was escorted to a conference room filled with photos of her, Mr. Tenon, and Mr. Fernandez, and Ms. Gardner, and posters of text messages between herself and Ms. Gardner. At this point, Ms. Jensen was left alone in the room with an extended period of time, just like they do for interrogations. At some point thereafter, ASA Stifler and ASA Mizrahi entered the conference room without any law enforcement. ASA Mizrahi told Ms. Jensen that she was an accomplice to the murder and threatened her with an arrest. Well, there you go. This is what I've been saying, right? Because it seems like if they believe what they're saying, they should have been charging her. At some point after, law enforcement entered the room. Ms. Jensen repeatedly stated that the text messages were taken out of context and that they were made in jest and not to be taken literally. At the end of the meeting, ASA Mizrahi instructed Ms. Jensen to never discuss her law enforcement. Oh my God. Oh my God. Oh my God. ASA Mizrahi instructed Ms. Jensen to never discuss her law enforcement interviews with anyone, not even her spouse. So the fact that they weren't recorded seems very deliberate, does it not? Holy mackerel. Which is what I was saying, right? Because we know these days everything's recorded. Oh my God. In addition to omitting the material information regarding Miss Lee and Miss Jensen, Detective Johns misled the court regarding Miss Gardner's knowledge of Mr. Tenon's blue truck that was allegedly driven during the murder. Because reports were turned over in discovery, reports that Detective Johns claimed he had not read as the lead detective, and I remember him saying that, Detective Johns was impeached regarding his material misstatements about Miss Gardner's knowledge about Mr. Tenon's blue truck following Mr. Tenon's arrest in August of 2022, before Mr. Tenon's association with the truck was made public. It is clear based on the reports and records that Mr. Tenon's roommate was informed, by the police the morning that Mr. Tenon was arrested that Mr. Tenon's truck was used in the murder of Mr. Bridegan, that the roommate called Mr. Fernandez shortly after detectives left, and that Mr. Fernandez contacted Ms. Gardner about speaking to the roommate and before she made any statements. Yeah, so we heard that in the hearing, right? That dispelled the thing about, consciousness of guilt regarding the truck. On May 24th, the court entered an order granting state's motion for pretrial detention and denying defendant's motion to set bond. The court reasoned its findings that defendant's guilt is evident or the presumption is great based on, quote, evidence in the form of statements made to Detective Johns, financial records, and defendant's text messages that support guilt. So why does this matter? Because remember, they have the opportunity to come again for bond. And remember, this whole thing, the reason why these bond hearings are more like evidentiary hearings is because the state is having to show, hey, what was the actual languaging here? The defendant's guilt is evident where the presumption is great, right? They have to show that. And so what Judge Kite ruled was it is based on the evidence in the form of statements made to Detective Johns, financial records, and the defendant's text messages. And I was even surprised. I was like, wow, I commented on that. I was like, looks like Judge Kite thinks those text messages were serious. But she used these text messages and the statements from Detective Johns to issue this ruling saying the guilt is evident where the presumption is great. We need to hold her here, okay? So this is saying, hey, this is clearly a basis upon which to reconsider, given this new information that has come to light about the nature of the statements made by, Kim. Ms. Jensen reached out to them to say, hey, this is bullshit, basically, right? And that clearly Detective Johns was probably lying on the stand, looks like, at least as it regards to Kim Jensen. So in the order, the court also made factual findings, the majority of which related to the statements allegedly made by the defendant to Ms. Jensen. The court asserts that these comments were the overt actions occurring over multiple years and were not just tongue-in-cheek comments a person makes out of frustration. Again, we read this, we saw this, we read this, and this is clearly refuting that they were in fact tongue-in-cheek comments, according to what Ms. Jensen is saying. So the law provides, as soon as practicable after the filing of the charging document, the prosecutor shall disclose to the defendant any material information within the state's possession or control that tends to negate the guilt of the defendant as to any offense charged, regardless of whether the defendant has incurred reciprocal discovery obligations, right? Due process. And this is where now we're getting into the Brady territory. We know that they have to disclose. So failure to disclose Susan Lee. Okay. The state failed to comply with its discovery obligations related to Susan Lee by not listing her as a witness in its discovery exhibit. More shocking was that the state apparently at all times intended to rely on text exchanges involving her to prove Ms. Gardner's guilt, and her defense team only became aware of the name Susan Lee on the eve of May 15th, 2024, hearing through a draft evidence list. The defense did not even see the text messages with Susan Lee that the state would admit until the midst of the hearing, at which time it objected to the admission of the text messages on various grounds, all of which were overruled by the court. More prejudicial was Detective John's claim that no one from the state had ever spoken to Miss Lee, where he in fact had spoken to Miss Lee and failed to follow up and interview her. In fact, when challenged, he lied about why she had not been interviewed, rather than admitting she was not interviewed because he failed to follow up with her. Only by Miss Lee watching the actual hearing and contacting a lawyer did this information come to light, because Detective Johns wrote no report regarding his communication with Miss Lee. And so apparently, it seems like Kimmy has followed her instructions from the prosecutor saying, don't ever talk about this, right? But remember, the important information that apparently was in her grand jury, I can't remember, was it grand jury testimony or in the interrogation? But again, this wasn't turned over to the defense, was where she stated that the messages were tongue-in-cheek. They were joke, they were made in jest. But again, we saw, and we will get to it, I'm sure, that apparently, again, at the beginning of this, it said, Kimmy also made a recent statement. So we'll see what the situation is with that. Had Miss Lee been properly disclosed by the state, whether on its discovery exhibit or in a report of the contact made by Detective Johns, the defense would have become aware through due diligence of her favorable statements regarding the text messages used by the state at the Arthur hearing. Here, given the volume of discovery, the defense had not previously identified Miss Lee or the text messages, and it was impossible to conduct this due diligence on the eve of the Arthur hearing based on a name without an address or the contact information mentioned on a draft exhibit list. Since the hearing, the defense has conducted due diligence. For example, those text messages used by the state are part of 48 text messages that date between Miss Jensen and Miss Lee, with messages occurring before and after that have nothing to do with the state's portrayal of an effort to solicit a, quote, magician. Because of the state's failure to list Miss Lee, the defense was prejudiced at the Arthur hearing. And then B, unrecorded interrogation of Kim Jensen. Yeah, that's a problem. The state, which includes both the prosecutors and Detective Johns, chose to suppress the true circumstances of and statements made during the July 2023 interrogation of Ms. Jensen at the state attorney's office. No report was generated, no recording was made. Nothing has been turned over regarding this meeting. Ms. Jensen was instructed to not discuss the meeting with anyone. The defense only learned of substantial material favorable information after the Arthur hearing. The defense was undermined and could not obtain and present favorable evidence, including evidence that would undermine. And remember, that's because after the Arthur hearing, they asked for the grand jury transcripts. And that's when they got the full context of what was said. That would undermine the veracity and reliability of what may be the most incriminating evidence introduced by the state. So I'll just add to that too, right? Had they had all those grand jury transcripts before, they could have used those at the previous Arthur hearing and or the bond. But now they have it. Okay. Importantly, the state chose not to call Ms. Jensen as a witness, which further implicates their knowledge that she would contradict their representations to the court about the July 2023 interrogation and their complicity in misrepresenting the true nature of Ms. Jensen's statements. This discovery violation clearly meets the three-part test to establish a Brady violation. First, the evidence withheld is favorable because it is both exculpatory and would serve as impeachment of Detective Johns. Second, the state willfully failed to timely disclose this evidence despite Ms. Gardner being indicted in August 2023 and facing the death penalty, and the interrogation of Ms. Jensen occurring in July 2023. And third, the defense was prejudiced because it was limited in its ability to challenge the alleged statements made by Ms. Jensen during this interrogation, and the court relied heavily on those statements in finding Ms. Gardner was not entitled to pretrial release. So there's a lot of issues going on here, but as it pertains to pretrial release, that was clear, right? The court did rely on those, but there wasn't the full context, and some of it was misrepresented, according to the defense. So knowledge of Henry Tenon's truck. So this they already kind of dealt with. We already kind of know about that because that came up. But here we go at the end here. So the defense now knows that Detective Johns lied to the court regarding numerous material facts and hearsay statements. The state further withheld favorable evidence from the defense and then capitalized on its due process violations at the Arthur hearing. Because this is a circumstantial case with no direct evidence of Miss Gardner's role in the murder of Mr. Bridegan, every fact of consequence and alleged incriminating statement made by Miss Gardner is material and could tip the scales both at trial and at an Arthur hearing. The state's actions violate the clear rules governing discovery and Miss Gardner's due process rights. The defense was clearly prejudiced by the state's actions at the Arthur hearing. If it wasn't for the independent acts of Miss Jensen and Miss Lee by coming forward, the defense would have been unaware of this favorable evidence. Clearly, the state's conduct warrants relief from the court, especially since the state was already on notice that its conduct in this case and discovery efforts have fallen well short of established conduct for prosecutors. The court should not ignore the state's cumulative conduct from the beginning of the discovery process in this case, including its failure to related to the taint review, which was the first whole issue, and its withholding of favorable evidence, and then available sanctions. Shanna Gardner, through no fault of her own, was substantially and materially prejudiced in her ability to present her defense in the Arthur hearing and only became aware of discovery violations. So it looks like Miss Jensen also came forward. Okay, so that must be that other statement. Right, so again, so the two statements, let me pull this back up. So the two statements, so that answers that question. So this was voluntary from Kim Jensen, I guess, contacting the defense. So both of these women came forward to the defense to make statements, it looks like. Wow. Pursuant to Florida rules of criminal procedure and the body of case law governing Brady violations, the sanctions available to this honorable court are, and I'm not going to read all of these because there's a lot and they're going to argue over this for sure. And the court should grant an order that is just under the circumstances of the state's conduct. Again, these are some more options there. Okay, so let me go back and take a look real quick here. Does it say? So her statement was from June 14th. So the thing is this, right? So remember, these were filed on June 21st. Okay, here's the part, right? So just to reiterate, so Miss Jensen did reach out to them, as I was saying. So she, I guess in a way, right? She was like, never mind, I'm not going to follow what the prosecution asked me to do. So first, Miss Lee was outraged and reached out, right? Miss Lee reached out May 23rd, 2024. Okay, that brings us to June 14th. Miss Jensen was similarly outraged by the unfair portrayal of the text messages and the failure of the state to accurately relay her explanations of the context of the text messages. Okay, she says similarly retained counsel and reported to the defense. Right. Okay. Right. Okay. So, and this is how they learned. Okay, this is how they learned. So in this statement, so she told them a lot. In this statement, this is where the defense learned of all of the circumstances related to the interrogation. All of this in here at number 13. That how they approached her at the supermarket. They talked about the subpoena. They couldn't find the subpoena. All of this. This is how they learned this. They learned this from her. So here's what I will say. That two things, well, not just two things, but the two big things that happened since the Arthur hearings, right, that bring us to today in terms of where we're at in this coverage are these two things. So after the last time that we saw the hearings, right, so there was nothing else that happened. What happened in the interim between then and now is both Susan and Kim reached out to the defense and made statements. And that brings us to June 21st with these court filings, and also brings us to Mr. Baez's press conference. So we're going to go to that now. I don't know if they're calling the judge biased. I think what they're saying is that the judge relied on what was presented, but what was presented was leaving a lot of things out, maybe inaccurate, also maybe, remember, it was based on two main things, right? It was based on the testimony of Detective Johns, which at this point looks very, very problematic because he made false statements, at least about his inability to get in touch with Sue and whatnot, right? But they basically have been impeaching him. They already were impeaching him, but now they've got even more. But also, it was relying on those text messages in which the judge said these were not tongue-in-cheek. But now the new thing that has come out is they've got these statements from Kim and from Sue, and Kim is saying they were tongue-in-cheek. And I said that. I said as much in my interrogation, and the state withheld that information. So you got to, this is incredible, right? So you've got people who were working with the state or whatever, according to the state, but they're like, hey, the state is flat out lying about what happened, about what we said. And, conveniently enough too, right? That they're like, well, we don't have a recording of the interrogation. So they are reaching out on their own volition to say, hey, this is incorrect. That is crazy. Wow. And so again, conveniently, Kim's interrogation wasn't recorded. And then conveniently, they're like, Miss Detective Johns is like, I couldn't get in touch with Sue. She changed her phone number. Blah, blah. Apparently all that is incorrect. She's had the same phone, and Sue says she spoke with him. We are going to learn a lot today, people. Okay, so that brings us to, hi, Black Widow, glad you're here. So, wow. So, I believe we already covered the Arthur hearing. I think we covered that on one of the other live streams. We did. I remember doing that. We may not have pulled up like his Arthur's case, but we looked up what an Arthur hearing is in Florida. We did cover that. At some point. I'm sure it's timestamped. Shout out to Frankie Figs. Glad you're here, Franks. Okay, y'all ready for some insanity? Get ready. So now we're going to go to the press conference. Remember, this press conference that we're about to watch is what follows Mr. Baez hand delivering these filings to the court on June 21st of this year. And you've got to understand why he's mad, right? Because I would like the fact, dude, this is insane. Okay, so let me unshare, reshare. Holy mackerel. Let's share this to you guys. Okay. Ready? Let's go.
First off, my name is Jose Baez. I'm the lead defense attorney for Shanna Gardner in the state of Florida versus Shanna Gardner. So, first off, the reason I've asked you to come out here today is because a matter of great importance and public interest has arisen, and I think it's important for everyone to have a certain amount of transparency as to what's actually going on in this case. I will start by saying this is not something I do often.
True.
In fact, it's the first time I've outwardly spoken in this case, other than a few brief comments for which I was approached walking to my car previously. Other than that, I really make very few public statements about the case.
Accurate.
Because I believe much of which should be done in the courtroom, except and unless there are matters of great public interest and importance. Having said that, I'll start off by telling you that my office has filed.
Right. So the thing is this, I just have to reiterate, right? So Shanna Gardner is being charged with first-degree murder, and they're seeking the death penalty. And it's entirely circumstantial, right? That, alleged that she reached out and hired someone to kill her ex-husband. Remember, the reason this matters is because a lot of what the state is using for that circumstantial evidence, whether it was in the bond hearing or whether it's going to be used at trial, has to do with Kim Jensen. And they're calling her a co-conspirator, right? Kimmy. And the fact that prior to Shanna meeting Mario, right? Back in 2015, 2016, 2017, there'd been all these text messages ongoing between Shanna and Kimmy where they joked about getting a hitman to kill Jared. But then apparently she took it a step further, that she reached out and asked Kimmy, hey, can you talk to somebody? Kimmy talks to Sue. Sue's like, I can't find anybody, blah, blah, right? Just to reiterate. And there was all this weirdness about how, Kimmy's interrogation wasn't recorded, right? There was no evidence of the Sue person, right? But then you have to remember that, just to reiterate, Kimmy and Sue watch the hearing and reach out to the defense and say, hey, all this is BS. The prosecution's taking this out of context. They're misrepresenting it. Here's what really happened. And this is the type of information that the state was relying upon to charge her with first-degree murder and seek the death penalty. And additionally, it's also the reason why Judge Kite found there was enough to hold her there on bond. So while we're getting into the bond and pretrial release, it's a lot more than that. Because honestly, if it's good enough, if this stuff is problematic, if these text messages are problematic, if it was misrepresented, if there were Brady violations, all this other stuff going on, if it's enough to say she should get pretrial release, it's probably also enough to throw out the case entirely against her, right? Because they're relying on it for both. So just to reiterate that. Okay.
Shortly, today, a motion in this case advising the court of certain violations of Brady material, which is favorable evidence that was in the possession of the state
Yeah, this
and not
is
turned
insane.
over to the defense. Much of what the motion entails surrounds incidents and testimony that was elicited during the Arthur hearing, which is a bond hearing on May 15th
The crazy
of this
thing to
year.
think about is this, guys. Think about this for as it pertains to just justice in general in this country, right? Had those hearings not been streamed and put online, you know what would never have happened is Kimmy and Sue would not know what the state was saying about them, right? They wouldn't know how the state was using the text messages or using the conversations, and they would never have reached out. They only reached out because they heard the hearing and they said, hey, that's not true. That's not fair. That's not accurate. And they reached out because of it. So this is why when we talk about transparency, it goes beyond just like, transparency to the public in terms of us seeing what's really going on in the courtrooms. But this is like such a bigger step in that you've got people who are key players in this case that the state is relying on, and they are being misrepresented, and they wouldn't have even known they were being misrepresented, be it not for the fact that they could watch the hearing and see it themselves. It's crazy.
Now, having said that, that is an opportunity for those of you who know or don't know, is an opportunity for the state to put on a certain amount of evidence to be able to show that the accused should be held without bond pending the outcome of the case. Now, during the course of that hearing, we learned of a meeting that took place between the two prosecutors involved in this case.
No, the fact we just learned the fact that they told her to never tell anyone about what happened in that room is insane. Again, I've said it before. I'll say, like, this does not feel like what should be happening. Like, this feels like we're in like a different country, right? Like, this is crazy.
One of them I see here today. I presume he's going to open himself up for questions after, and I would invite that, of course, to hopefully respond to some of the issues that occurred in this matter.
So Mr. Mizrahi is out there, I guess, watching this.
First off, it's dealing with the testimony of Detective Johns, who during the course of that testimony elicited or spoke of certain text messages between a individual whose initials are KJ and another
Jensen.
Person's whose initials are SL. This name had never been made known to us previously up until the night before the hearing.
Yeah, that's not good.
We objected to these text messages from coming in, and that was overruled. So they did come in a matter of course. We don't take issue with that. Detective Johns testified that he never spoke, that he believed one of his other officers spoke with this witness, and that he did not. When pressed, he later stated that the witness had changed her phone number and they had a hard time getting a hold of her. The SL was actually watching the hearing at that time and was outraged by the lies told by Detective Johns in this matter. And I'll remind everyone.
For anyone who missed it, by the way, this was Detective Johns' first homicide. And when we were going through this bond hearing, and I did the math. I joked, I'm sure it's timestamped, right? When he's like saying at the time of the bond hearing, he's like, yeah, I've been a detective for 5 years. And I was like, wait, hold on. That means he must have been a detective for 2.5, 3 years at the time of this. And I actually made a joke that I thought to myself, wait, don't tell me this was his first homicide. There's no way. And then on cross, Mr. Baez flat out asked him, was this your first homicide? And he said, yes. I was like, I thought that to myself as a joke. And then I was like, there's no way, right? It was his first homicide, and he was just a new detective anyway. So, but now also he apparently has lied to the court and everyone.
A penalty case where the state is attempting to utilize the color of law to kill another human being.
Mm-hmm.
So, as part of this is testimony. Number one, it turns out that Miss SL did not change her phone number. She has the same phone number and has had the same phone number since 2014. So that was an outright lie. In addition to that, no other detective spoke with with Miss SL. It was Detective Johns who in fact spoke with Miss SL.
Wow. Wow.
That was his second lie.
Wow.
And that was upon being pressed. Now, these are clear, unambiguous, straight up lies made by the lead detective involving a critical witness who was allegedly being solicited for to hire a hitman for murder. As it turns out,
wow.
The actual truth was that this was a running joke between the two witnesses that I previously mentioned, who apparently witness SL's husband is an African American, and there was a member who she worked with who had specifically approached her and made an offensive comment asking whether he knew any individuals who were involved with crime. So naturally, amongst friends, they continued to chide her, and that's specifically what was done within those text messages. They were text messages made in jest, and as you also heard during the course of that hearing, there was this meeting between the two lead prosecutors as well as the two lead detectives with KJ. KJ also got to view this hearing, and as it turns out, was equally enraged by some of the lies told by Detective Johns and some of the key facts omitted by the prosecution, such as the statements and many of the text messages that were displayed in an attempt to keep Shanna Gardner in custody. They were told specifically by KJ that many of them were made in jest, and they were not taken seriously by anyone.
And that is really important because, again, that's been the thing that was being discussed, right? Like, because even before he had heard, because when they had that Arthur hearing, right, the bond hearing, he hadn't heard from Susan. He didn't even know she existed until the night before or whatever, morning of. But he was able to point out by looking at the text messages, he was able to point out and say, hey, like, these clearly are a joke, because, you know, he went through them and was like, see how they kept saying that they're gonna kill Enterprise, and they're gonna kill so-and-so and kill their, you know, it was, and that's when he was able, and that's when I was like, yeah, that's a good point, because there's a lot of them that are clearly jokes, right? That's one thing. But to now have heard it verbatim from the person who was involved, and that she said this was an inside joke, and here's how it was an inside joke and whatnot, that's completely different. And remember, again, the state is relying on these text messages. They're relying on them for their case. And the judge relied on them to hold her in custody and not grant bail.
And in fact, many of the individuals who were surrounding this case knew that. This critical information, which is exculpatory information, was never disclosed to the defense. And it wasn't until after the Arthur hearing that we were able to uncover that these statements, for which are non-recorded and no police report was done. I think that's worth mentioning here, because I don't stand here and take this situation lightly.
Nope.
I realize that I'm being highly critical of both prosecution and law enforcement in this case, but it does not come easy for me.
Right.
But I hold them to the highest standards, as we all expect our elected officials and our public servants to act. And in this situation, that critical information was not disclosed. And as you saw during the hearing, I was highly critical. Here's
the thing. Any other defense attorney would be way madder than he is. I wouldn't even say that he's angry at all. I wouldn't say he's angry or mad. I think he's just this is what's happening, you know? And the thing is that, you know, he wants to fight a fair fight, right? It should be fair. Like, you know, and the thing is what is happening here is not fair. And one has every right to be, whether it's critical. I mean, I don't even know that you could call it critical. It's like he's really just stating things that happened point blank without characterizing them, right? He's not calling anybody slimy or sneaky. Like, you hear that stuff in cases, right? Where the people use names. He's not even saying that. And he could. He's not even bad mouthing or calling the detective names, right? He's just saying this came out. These statements were misrepresented. This is untrue, blah, blah, stuff like that. I mean, so to me, this is all very fair from him.
Of the fact that they did not record this
he yells in a few minutes.
And that they did not write a police report stating as such. So, my position is simple. Even held in the best of lights, with the best intentions, completely honest intentions, if you have 4 highly trained individuals getting a statement from the most critical witness in the case, you record it. Otherwise, you're incredibly incompetent, and perhaps they should be fired for that reason. I would want police officers investigating a crime that I believe is incredibly important, especially one to me, to do their job appropriately and competently.
Let me say this. The reason he's saying this is because, okay, I commented at the time too, right? The fact that it wasn't recorded is so implausible to me, because we know, and especially in Florida, they're all about transparency. Everything is recorded. Everything is recorded, right? It's like automatic. I even made a point too that you would have to honestly go out of your way to have something not recorded. And that's part of the problem, right? We know that a lot of these rooms, there's automatically, there's a camera running, and you would have to go out of your way to turn it off. So I think what he's saying is like to say, okay, yeah, they weren't trained enough, they were incompetent, that they didn't know they should record it. That's the nice way of putting it, because the only other option is that it was done intentionally. In other words, that it was intentionally not recorded. But even worse than that, the only other possibility would be it was recorded and then that was somehow disappeared, destroyed. Now you're getting to willfully destroying evidence, So again, what he's saying is the best case scenario is that they were incompetent. Okay, that's the best case scenario.
And clearly that's not done, and nothing's being said or done about it.
Franks.
And that's a big problem.
I didn't know you were Italian, Franks, but that's really funny.
You can't expect
they should have reached out to you.
Our public officials accountable if you don't hold them accountable. So in this case, let me finish. There's more information I have to disclose. So you have the situation where this secret meeting is taking place with no recordings and no police reports written on the meeting, and no disclosure to the defense.
And I commented on this too, because I was like, with that being the case, right? It's a secret meeting. It wasn't recorded. What happened to these Arthur hearings, right? You've got law enforcement, you've got the prosecutors that are saying, here's the statement that was made, but there's no way to really know, right? And that's why it's so crucial and so incredible that Kimmy reached out to them, to the defense, because the only thing that can refute what they say is if she comes out and says it, right? That this is why you record things, and then there's no question. Anyway, it's just incredible, right? Because again, you had these statements put in quotations. It was used in the PowerPoint. They had in quotations statements from that interrogation. And in my mind, I'm thinking, well, we don't really know because it wasn't recorded, Anyway, wow, this is crazy.
When we are trying to seek release from pretrial custody, which are founded on constitutional principles, such as the presumption of innocence, such as having your day in court, such as holding the government to its full burden. All of these are ignored and being circumvented. Just because it's popular doesn't make it right. And furthermore, what did we learn from this overall hearing? Well, there's some ugly text messages, and that's it. I don't think anyone learned any more information about Shanna Gardner's alleged involvement, or non-involvement.
It really was the bulk of what they presented was the text messages, 100%. And they looked damning, right? If you were to go and say, yeah, all these are true, well, I say that. It looked damning, but then again, if you go ahead and say, yeah, they were being serious in all these text messages, it's like, well, then how come there's not 50 other people that are also dead? But yeah, that was the bulk of it.
Other than there were some bad text messages, who we now find out were as a result of many of them ingest, taken out of context. And if that's all you have, so what do you do next? you manufacture a case. And I'm not saying that we're at that point yet, but I see very, very potentially harmful things.
I mean, what is
along the
going to
horizon.
have to happen is we're going to have to hear from Kimmy and Stu. Like, that's going to have to happen. And I wouldn't be surprised if they have to go, you know, one by one through those text messages and ask Kimmy, was this a joke? Was this not a joke? Was this a joke? Was this not a joke? Because the thing is like then there's the text messages that deal with Jared, right? And is she going to say, yeah, the other ones were a joke, but those weren't? I don't know. We'll see.
Such as having meetings and not recording them, having meetings and not doing police reports, and not disclosing favorable evidence to the defense. As early as yesterday, the prosecutors turned over more additional statements that were allegedly made by KJ at this secret meeting.
Oh boy.
Many of which KJ even denies that were ever said.
Wow.
And KJ also says were taken completely out of context and spun in a direction that was wholly inappropriate.
One thing I will say is this: if it comes down to a thing of one person's word versus another, because if it really wasn't recorded, right? If it really wasn't recorded, which is what they're saying, if it comes down to Kimmy says, hey, that wasn't what was said, and then the prosecutors or Detective Johnson, that's what was said, they're going to have to hash that out. But here's the thing: and I've said this, I'll just reiterate, if the prosecutors and if Detective Johns, if law enforcement, if they truly believed in what they were saying, it makes no sense that she wasn't charged, right? I've been saying this the whole time because it doesn't make any sense. It's like something's not adding up here, because if they truly believed what they were saying, they would be charging her, because they're calling her a co-conspirator, but they're not charging her, right? So when you look at it with common sense, in a way, it kind of would point in Kimmy's favor if indeed she does come out and say that was taken out of context, that was never said, blah, blah, and you're trying to weigh it out, who's who to believe. The fact that they are not charging her would almost say maybe they did know at some point. They were like, yeah, these were made in jest, these were jokes, right? Or that this wasn't said at all.
Prosecutors don't have a case. These are the things that are done. And I will tell you what happens next. When you don't have evidence and you have a case like this, the next inclination is to go out and get yourself a jailhouse snitch. So I presume that's being done right now. There's a little shopping that might be going on or might not be.
Oh boy.
But as a result, what we have done is we are sending a letter to the elected state attorney, in this case, Melissa Nelson, and we're going to be, and as well as law enforcement in this case, advising them that Shanna Gardner is represented, and they are not to send in any agents of the state to try and go in who are actually trying to make a deal for themselves and trying to better their current situation while in jail, to be able to hurt and harm Shanna Gardner in a death penalty case. That's a textbook move, and we are calling them out. And I'm telling you right now, if that happens in the future, you will be able to go back at this moment and you'll be able to know and see that I was absolutely 100% correct. So watch out for that. That's coming next. And you cannot have, under any circumstances, a police officer lying in a court of law, lying to a judge who has to make the critical decision to hold someone while in custody. Everybody forgets Shanna Gardner has a child who is terminally ill. You have this child who may not live.
I didn't know he was terminally ill. That's
completely torn away from his mother while she waits. Could be a year, could be 2 years, could be even longer for trial, and for which you're seeking the death penalty. The stakes couldn't be higher. And in fact, the actual conduct couldn't be more egregious. This is not something this community should stand for. When they elected Melissa Nelson, they should have expected her to hold her standards, her prosecutors to a heightened standard for which they can fully work within the public trust. And that doesn't mean violating agreements while maintaining attorney-client privilege materials, for which this court has even acknowledged was poor judgment. And now we have this, withholding favorable evidence from the defense prior to a critical hearing, and then later on afterwards, doing it again even more. As recently as yesterday, we got more statements that allegedly occurred during the secret meeting that was non-recorded. So, folks, I employ all of you who are here to, we're trying to do our job. We want you to ask the tough questions. Don't take the guided tour. This case is not as simple and as open and shut as it has been laid out to be. You have only heard one side of this case, and what's coming out of it reeks. And I think all of you, I think it's your journalistic responsibility to seek out and ask them, why are you putting on a police officer who's lying on the stand?
Well, this is important. So what he's doing is he's imploring these journalists to say, hey, why don't you guys ask the tough questions of the prosecutors? Remember, Alan Mizrahi is apparently right out there, standing there with them. He said so. Ask the tough questions of the prosecutors, ask the tough questions of the detectives, because we see that in a lot of cases, right? But that hasn't, at this juncture, I haven't seen it being done here yet. Maybe it will, I don't know. But what he's saying is like, hey, it's up to you guys to like ask these tough questions, and because this is about the public, right? Melissa Nelson was is an elected official, and she's supposed to be representing the public and putting their best interest first. And this is not that, as we're saying.
Why are you allowing that to happen? Why aren't you recording meetings with very important critical witnesses? Why are you not getting these statements completely locked down? And ladies and gentlemen, I will tell you, there's a very good reason. And the reason is an obvious one. So I would ask that all of you, and even those who are listening, to seek out and ask these questions and hold them to their level of professionalism. And I can tell you this, it gives me no pleasure to stand here and do this. None whatsoever. I hate it. Hate it with every being, every part of my being. But I will do it. I will fulfill my oath as an officer of the court and as the lawyer who's been entrusted with Shanna Gardner's life.
And this is true.
They're not going to get away.
The thing is, he doesn't come out and make these. This says a lot. I remember when I was first started researching and getting ready to do this case, and I saw that this existed. I was shocked because I knew something was really wrong, and that's exactly why he's speaking out, because he's like, this is so bad that people need to understand, right? People need to understand that this is this warrants this level of public knowledge, because this is such a big deal, that, even I, Jose Baez, who never makes these public statements, this cannot be ignored anymore because this is that egregious.
Lying in the courtroom. We're not going to stop until we seek justice in this case. They're not going to get away by creating evidence, and we're not going to allow that to happen in this case. I certainly hope that if there's any ambiguities, that they clear them up immediately, that they explain why they didn't record that meeting, why they didn't file a police report on that meeting, why Detective Johns is lying about speaking to a person when in fact he actually did, lying as to why she changed her number when in fact she still to this day has not changed her number. There's no reason any of these things could have had to have occurred in this case. If they really have a case, if their case is as open and shut as they say it is, to the point where they're confident enough to seek the ultimate penalty of death, then none of this should be going on. None of this. And the fact that they expect us to stand by and let it occur just isn't going to happen. Just is not going to happen. And I ask that all of you ask the tough questions. And by all means, if you want to ask me questions, I noticed Mr. Mizrahi left.
There it is.
He doesn't want to answer to his.
There it is. Mr. Mizrahi left. You know what? I bet he left. I bet he left as soon as Mr. Baez said to the media, ask the tough questions. Ask them why. I bet he skedaddled on out of there like a weasel. Wow. That is, wow. That says a lot right there, right? Because he should have been willing to stand there and answer questions if he had felt like if he didn't have something to hide. Jesus.
Actions. So
he left.
It is what it is.
Oh my God.
Perhaps he had another matter, and you're, in fact, he does. So I take that back. The reality is you need to ask him. Ms. Stifler or Melissa Nelson these tough questions. And I think they owe the public answers, especially if they're putting on such type of evidence.
Mr. Baez, I was just hoping to get some clarity. What specifically are you requesting in this motion? Is it a consideration of the bond? And
Well,
two, how did you learn that this witness? How did you learn the additional context this witness?
Sure.
Provided to you?
Well, it's all laid out in our motion, so you'll be able to see it. But I will tell you this. First off, we learned about it because they were watching the hearing. And that specific witness, the first thing she did is she hired a lawyer. And that lawyer then contacted us. We were since able to obtain a sworn affidavit. And in fact, we even have the phone records from when Detective John
Oh my God.
actually called her.
Did you guys hear that? Hold on. What the fuck? What? The fact? Here's the thing. The fact that Detective Johns lied about ever being able to speak to her, he said he couldn't get her phone number, no one spoke to her. What that means, what that says to me is this. He never thought that Susan Lee, would ever speak up about it. That's what that means. He thought she would just not care, or she would, and he was wrong. This is insane. Listen to this.
Obtain a sworn affidavit. And in fact, we even have the phone records from when Detective John actually called.
So they have proof, in other words, not just witness testimony. They have proof.
Her.
Oh my God.
There's no getting out of this one. And in addition to that,
this is going to be insane.
Both witnesses submitted affidavits clarifying their position and basically saying that these statements were completely taken out of context and that are completely and utterly false.
And so filing this motion, what is your expectation or request of the court?
We're requesting, the court has numerous and broad discretion in a situation like this. She can dismiss the case. She can dismiss the state attorney's office and disqualify them. As we know, this is not their first brush with incidents in this case. And she can also give us reconsideration for the bond hearing for which we're asking. We're asking for Shanna Gardner to be released. And that, of course, is one of the remedies that we're seeking as well.
And the individuals that have come forward that would allow you to file this motion, they would speak publicly if necessary?
If subpoenaed to testify, they would testify to the truth of what they're saying, yes.
There have been hearings in
Here's
this
the
case
thing.
to talk about.
There's no way, and I haven't watched it because I don't want to have the spoilers, but we're going to be watching the next hearing. There's no way that either they don't have Kimmy and Sue testifying there, or at the very least, they're going to have their statement. Like, that's going to have to happen because that's what's going on. Like, this is critical.
About discovery and things like that moving forward after the issues we've had with discovery previously. Why not bring this up at the next hearing? Why take this, drastic of a step rather than bringing it up before a judge?
Well, it's not a drastic step. It's drastic conduct. Okay, so you have to respond in kind. And number one, this was the first. As soon as we found out about this information, we immediately got affidavits to ensure that this testimony is sworn. Mm-hmm. And in addition to that, what we did next is we filed a motion. So there haven't been any court appearances since we've discovered all of this information. Yep. But I can assure you, they're all significant discovery violations. They disclosed some of the statements made in that meeting almost a year ago, okay? But they completely withheld the rest. And they absolutely withheld all exculpatory statements. How do you do that? Would any one of you want your family member or your fellow citizens to go through a system of justice like this? I would answer for you an absolutely no. And I tell you, I believe, these things require them to answer.
They do.
And the only way we're going to do it is by exposing it and having full transparency.
Yep.
Do you want to see Detective John barred from testifying in future hearings or at the trial?
There are a number of remedies that the court can fashion. That is one of them, as well as a potential jury instruction. And I don't know why you guys put me out here to fry like this in the hot sun.
We asked you for all this.
Yes, but not in the we were told you wouldn't do it under a tree. But regardless, I am sweating like crazy. What's that?
Yeah, so this is June in Florida. So
Okay, I got you. Any other questions?
Are you basically saying that Jacksonville Beach Police Department kind of botched this investigation?
No, I'm not saying that. I'm saying that they lied.
this is so important, right? He's not making these broad sweeping claims. He's not saying everybody, but but I'm glad that they asked that question so he can clarify in case anybody wants to misinterpret what he's saying. He's not saying that. He's not besmirching the entire police department. It's literally really comes down to Detective Johns is what it seems like here, because he made all these decisions. He's the one who testified under oath and made false statements, right? He's the one who talked to these witnesses.
Under oath in a court of law.
Mm-hmm.
And I think that's a fair interpretation of what the witnesses are saying. And you can't hide it.
And again, I want to reiterate, the thing is that regardless of what the witnesses say, right? Because again, you could have whose word are you going to trust? The fact in and of itself that they have the phone records that show the phone call, that right there already is enough to say he was lying, right? Regardless of that's that is physical evidence to the contrary.
There's no disputing the witness's phone number is the same. There's no disputing the phone records.
Yeah.
There's no disputing any of that. I think there's complete.
As I was saying.
There's
yeah.
An accurate and complete account of what actually occurred, and it's not as what was testified to.
And with this, you're going to, I'm assuming you would want this case to be moved out of this picture.
Shanna wants to clear her name. She's innocent. And,
wow.
One face is enough when the state of Florida decides to charge you with a crime.
I believe she's innocent.
And then charge you with the death penalty and to seek the death penalty. So I don't know how one deals with that other than fights it, and I think this case
and again, I just have to say, just because I feel for him with the pressure, because again, as of 2023, for anyone who has not heard me say this or anyone else say this, Florida changed the death penalty to where they only require 8 out of 12 for the jury to vote for death, where it used to be 10 in Florida. And in every other state in the US that has the death penalty, with the exception of Alabama, which is also 10, all of them are unanimous. So Florida is an anomaly, 8 out of 12. And just imagine, especially if you believe that your client is innocent, I can't even fathom the pressure, right, on that.
Equally important to everyone, because if this is the type of conduct and these are the type of things that are done in this case, when everyone is watching, you can only imagine what's being done when no one is watching.
Let's listen to that again. That's the point. He's absolutely right. He's absolutely right. Truer words have never been spoken. It gives me goosebumps.
And I think this case is equally important to everyone, because if this is the type of conduct and these are the type of things that are done in this case, when everyone is watching, you can only imagine what's being done when no one is watching.
Wow.
And
scary.
And I think these cases are incredibly important for that. And trust me, I have extensive experience in cases that are high profile when people are watching.
We know.
And if you're sloppy and you do this in a high profile case, you absolutely do it when no one's watching. And that's a scary thought here.
Yep, that's scary.
It's a scary thought when a arm of the government has the ability to sanction the killing of another human being, and to do it in a way where evidence is not what it's supposed to be.
So you're going to file this motion, leave it in Judge Kite's hands about what to do next.
Correct. All right. Thank you.
Okay. So this press conference was before he filed the motion. So I thought it was after. Either way, same day, right? So he files. Let me pull up. Hold on. So he files. He goes in and files the motions that we just read. Okay. So now, let me get this ready. Give me just a second. Get this queued up here. Okay. So now Oops. So now the next thing, so now we have the next court filing. And what it is, let me just look at my timeline here. So, okay, August 16th. Okay, so now let me pull this up to you for you guys. Okay, so they're going to have the next hearing on August 16th, but this is the next court filing between what we just covered and the next hearing. Okay, so there's more. July 25th, right? So that was June 21st. So now we're on July 25th, 2024. So this is the state's response. Okay, state's response to defendant's motion to release defendant for failing to disclose evidence. The state, by and through the undersigned counsel, file its response. All right. Defendant's motion alleges the state failed to disclose favorable evidence to the defense while capitalizing on such failure during the May 15th Arthur hearing. Specifically, the defendant claims the state failed to comply with its discovery obligations by 1, not disclosing favorable information in statements made by witness Kim Jensen, and 2, not listing Susan Lee as a witness. In addition to these claims, defendant alleges that Detective Johns lied to the court regarding numerous material facts and hearsay statements at the Arthur hearing. The defendant's claims are without merit. Okay. Okay. So defendant's motion claims Kim Jensen provided favorable information in an interview with police and prosecutors that was not formally disclosed to the defense. Defendant's motion fails to identify any specific statements made by Jensen that the state was obligated but failed to disclose. And then there's a footnote. Before filing the motion or serving the state with the motion, defense counsel held a self-serving news conference. Oh my God, on the courthouse steps to announce the filing of the motion. During the news conference, defense counsel made sweeping accusations regarding the practices of law enforcement and the state attorney's office. Despite the theatrics, you guys, wow. Despite the theatrics, counsel failed to identify specific exculpatory statements the state should have, but failed to disclose. And then they have a YouTube link for the news conference. Oh my God, the spice. Defendant argues the state should have disclosed Jensen's, and then look at this, in italics, opinions or observations from Jensen on defendant's state of mind that incriminating text messages from the defendant were taken out of context and were made in jest. Defendant disagrees that these messages are in fact evidence of defendant's guilt, a position her counsel vehemently argued to the court during the hearing. Since the hearing, defendant claims Jensen is, quote, outraged by the unfair portrayal of these text messages. Jensen's opinions regarding the context of these messages has been known to the defendant since discovery was provided. Oh my God, the arguing that's going to ensue is going to be crazy. By the state in November 2023, specifically, the assistant state attorney had a phone discussion with defendant's counsel on November 13th regarding both the text messages and unrecorded statements provided by Jensen. The assistant state attorney advised counsel to seek to unseal Jensen's grand jury testimony, even though the state did not believe this to be Brady. This is one of those logical fallacies, because what they're talking about is the grand jury testimony, and that is not what is at issue here. It is the statements made in the interrogation, and they know it. Defense counsel acknowledged this conversation in an email to the state and defendant's unopposed motion for, like, look at this. See what they're doing? They're swapping it for the grand jury, but that's not what's at issue here. The court granted this motion. This is silly. I'm not even bother to read it until you get to the part that matters. I mean, the grand jury testimony is not what's at issue. Oh man. All right, let's see. The state also tendered to the court text communications between the defendant and her friend Susan Lee, wherein the defendant sought help in finding someone to kill Jared Bridegan. To date, Lee has not been listed by the state as a witness. Defendant alleges that Lee, after watching the Arthur hearing, was upset that Detective Johns testified he'd not spoken with Lee, which she claims he had. Based on this, the defendant claims Detective Johns lied to the court regarding numerous material facts and hearsay statements. This claim is false. Well, it looks like they say they got phone records. So during the hearing, Johns clearly could not recall the details of law enforcement contact with Lee and explained he did not have case file reports with him. And I remember thinking that something was fishy there, because it was like, why did you not bring that with you? Anyway, if Detective Johns' recollection was mistaken, he will be subject to impeachment during any future testimony. So best case scenario, like, you can impeach him. Defendant is likewise frustrated by its disagreement with the state's view. Okay, there's another footnote here. Hold on. Where's footnote 2? Okay. In defendant's motion, she acknowledges she received and interviewed Kim Jensen's testimony prior to the hearing. And here's the footnote. This transcript is replete with Jensen's subjective feelings about the meaning behind the defense. Again, irrelevant, because that's not what's at issue here. Okay. So, right. So again, impeachment. Defendant is likewise frustrated by its disagreement with the state's view on the evidentiary value of the communications between defendant and Lee. In a statement allegedly provided to the defendant after the hearing, Lee purports the communications were part of a larger ongoing joke. The state disagrees. Ultimately, the court or a fact finder will determine the evidentiary value of these messages. Contrary to the defendant's claims and or counsel's accusations, the state has committed no Brady violations related to these messages or their sender's subjective opinions about them. The defendant's motion is without merit, and the court should summarily deny it. And it comes from Melissa Jensen. Oh, what have we here? Oh, this is just showing that the communications about the grand jury testimony. And this is again from, yeah, that's the fact that they're including this is so silly because it's like, that's not what the issue is. Okay, great. We're done with that. Now it's time for the next hearing. Oh boy. All right. Because this is what's coming up next in chronological order is this hearing. So this hearing will be from, what did I say? It is August 16th. Okay. Here we go. Let me go to where they start. Okay, cool.
Thank you. Good morning. All right. If the attorneys would please place their appearance on the record.
Mayor Christina Stifler and Alan Mizrahi for the state.
Right.
Good morning, Your Honor.
Good morning.
Jose Baez, Patrick Carodi, Rosemary Peoples, and Armando Luis for Ms. Shanna Gardner.
All right. Thank you. Good morning.
Good morning, Your Honor. Jesse Dreiser here on behalf of Mr. Fernandez, along with Shannon Day and James Hill.
Thank you. Good morning. All right. I am going to file the order related to I'm granting the defendant's motions for protective order. And I have exhibits that I'm going to attach to the order, but I'm going to direct the clerk to redact the contact information before posting and filing the order. Is that agreeable with all parties? The list that you gave me. So the list of attorneys' contact information that may be contained within the electronic evidence. Additionally, I didn't know if the lawyers wanted to redact certain portions of the evidence. It seems some of the email addresses appear to be that need to be redacted for public disclosure. However, I don't know if the lawyers have any issues with the actual evidence and how it's listed as being redacted. Do you know what I'm referring to?
No, I know the list, Your Honor, that I provided the court. Is that, it sounds like there's something else that you're referring to.
Yes, let me see the lawyers at sidebar.
Sidebar.
Certain portions that would be uploaded should be redacted, and they're going to remain and say which line numbers on the exhibits. Okay. All right. Is there anything that the lawyers would like to take up?
On behalf of Mr. Fernandez, Your Honor, we sent over a courtesy copy. Did you receive it for a motion to set depositions of minor witnesses?
No. When did you send it? Okay.
Those be the children.
The motion appears as if, we're not communicating and having difficulty. It's not the case whatsoever. We had been trying to set, at the request of Mr. Fernandez's legal team, the depositions of the minor children of Jared Bridigan. And
so this is a long hearing, so we might split it up into two. It just kind of depends. I've got it at 1.25 speed, but sometimes there's breaks or whatever. So we'll just kind of play it by ear. We might split it up into two, but who knows? It might be that we can actually get through all of it if it's I don't know, not that much in terms of the actual testimony, right? So
co-defendant. There's no issue. No one has any objection to us setting the depositions.
And in
when
fact,
we tried,
to that end, I'm going to go forward a little bit because we've got to get to the testimony.
and I expect she'll
Housekeeping.
either have Mr. one sit in, and I think a guardian out after. I just know that if we don't set.
Let me pause it and fast forward so that way it doesn't sound weird to you guys. Wait, did I see Chat GPT? Hold on. No, CPT. Okay. They're just talking about getting depositions from the kids. Still talking about the children. Okay.
Like Shanna Gardner during the course of the investigation, who fully gave on both analysis of children. The Gardners themselves are not trying to frustrate this process. They're trying to.
Still children. Okay. I think they're talking about the guardianship issue, which recently was resolved, but that's not, I'm not worried about that here.
Party. At some point in time, you would think that if they are called as witnesses, they would be brought to this jurisdiction to testify potentially. So what is the harm in having the victim advocate here sit in on the depositions?
There is no harm. I was coordinating just to have, whether it's the victim advocate here and we fly out someone, a victim.
Looked like the state was pushing back on having a victim advocate, and the court is like, what or why?
Advocate here to fly out to Washington.
Doesn't surprise me. Doesn't surprise me. Okay.
In those proceedings, children would have guardian ad litems appointed. They don't, they generally speaking, at least in this jurisdiction, do not participate in criminal matters sitting in on depositions. A victim advocate isn't generally a lawyer, but trained for certain situations like what we're talking about. So
Again, I'm going to go forward a little bit. Let's see. Still talking about the kids. And of course, anything that's done with that is going to be, under seal anyway. So they're just talking about the logistics.
Conversation that went sideways maybe about expectations. And to me, there's a practical solution to all of this. Either y'all can agree in the location. It's not someone that's going to really enter the children's lives just to facilitate a deposition. I don't see what the harm is in that. But if you do have an issue, bring it to my attention. And I also think a lot of whatever you're saying, a third person in the room, a lot of this could be solved by y'all buying a plane ticket and going out there.
Right, but that puts more people in the room with the child. But anyway, we're the parties.
I don't know what this third person in the room is, or other person in the room is all about. But so I'm going to hold this motion.
The judge seems very confused by what the state is suggesting about the third person. Okay, let's just see where we're at here.
It's going to be a long hearing. I know if you're going to do a past date, and I'll accept whatever past date you give.
Okay. All right. Let's focus on getting a date for the depositions.
Okay, so they're going to talk more about getting a date. So it's interesting that Mario's defense. Okay, now they're on break. So this is what I was talking about. So now we can skip over. They're on break. Okay, it's interesting that Mario's defense team is there.
Washington to coordinate all that.
And Mario.
I assume the deposition will last from 3:30 till 5. And imagine it going longer than that. But.
Sounds reasonable, Your Honor, but of course we'll defer to.
All right. I can communicate the past date unless you all have some conflicts you want me to.
Okay, again, scheduling for the depositions with the children. Oh, so now Mario's leaving. Okay, well that answers my question because I was like, this is going to be about Shanna because of the bond. So he was there because as it pertains to his case, this looks like because of the scheduling. Okay. But it looks like they escorted him out. Okay, so.
And I reviewed the state's response to that, requesting that the court summarily deny it.
Okay, this is what we're here for. Let me back this up a second. Okay, here we go, guys. So now they're going to be arguing on the filings we just read. Here we go.
All right, and so I did review, I'm assuming the witnesses are related to the motion that was last filed. Is that correct, Mr. Cody?
Oh my God.
And I reviewed the state's response to that, requesting that the court summarily deny it. I still have the same view. I think that while not necessarily phrased that way, based on the law, I'm going to just do the inquiry. So if they want to present evidence, and I'll allow the state to respond in kind. So Mr. Curdy, you can go ahead. Susan Lee.
Oh my God, here it is. Oh my God, I'm going to lose my mind. They're calling Susan Lee. Here it goes, guys. Oh my. Okay, I can't believe that this is happening. So we're probably going to hear from Kimmy as well. So they're calling Susan Lee, and remember, this is who was supposed to be like essentially like a Mario role, right? Like, well, I guess kind of like a Henry Tenon role. Like she was supposed to help find a hitman for Kimmy for Shanna, allegedly. Oh my God! Wow! Holy fuck! The state has called her a co-conspirator, by the way. Okay. Wow. Wow.
Yes.
Good morning, Ms. Lee. I'm holding in front of me a two-page document that is 10 paragraphs by Susan Lee.
Okay, I'm just gonna pause it real quick to say the sound is awful. There's nothing I can do about that. It's all the way up. This is what is happening in court. He's probably away from the microphone so he can stand in front of the camera for the Zoom thing. Okay, that's what's happening here. So that's why it's hard to hear him. That is Mr. Carodi. So she's being called by the defense. Okay, so Mr. Carodi is one of the defense counsel. So what he's saying here is, I'm holding up a two-page document, and what I would imagine he's saying is that it is her affidavit, right? Her sworn statement that she presented to the defense. We already heard reference of that. That was referenced in the court filings, was talked about at the press conference. So this makes sense that that's what he's going to be starting with. Like, this is your sworn statement. This is your affidavit. This is what I'm holding here. And now I'm going to ask you questions about it. That's what's going on.
And Your Honor, I would like to admit Defendant 1 into the record. Copy which has been provided to the city. It's a statement by Ms. Lee that she previously provided.
Any objection? Okay. All right, that'll be defense 1 for the hearing.
Now, Ms. Lee, phone number 904-270 on June 23, is that correct?
Yeah, the audio is terrible.
And on your smartphone, did that show up as a call from a particular agency or company? And as far as the time, was that call at 2:52 p.m. your time? And where were you living at the time?
He's asking her questions about the phone call she had with Detective Johns.
I couldn't understand that. Did you say Minnesota? Okay, thank you.
Ms. Lee, when did you move to Minnesota? And prior to June?
Okay, so she moved to Minnesota in June of 2016, and before that, she lived in Florida, I would guess.
And as far as the date and time of that call, how are you the date and time of that call today in 2024? So it's on your cellular phone records. And if you go back and review those prior to signing that statement in May 2024. Now, did you answer that call at 2:52? Was there a second call or a minute later? Yes. Did you answer that call?
Okay, it looks like there was a second call.
Can you tell the board your own words about the exchange with the
Are we going to be able to hear any of it?
I can't understand it.
So, okay, so that, at least it's not just us. If Judge Kite keeps interjecting, then maybe we'll be able to hear her better. Not really, no.
Can she try?
Judge, can we approach briefly?
Sure.
Okay, maybe they're going to sort it out. Let's
So we have the author.
I think they're going to try to sort it out.
I don't know if it's the acoustics in here or what.
Technical difficulties.
Maybe turn the
Yeah, I was thinking too. She needs to just not use the whatever she was using.
volume back up. It's better without the headphone.
Yeah,
Can you, I'm sorry.
they're trying to sort it out. What is going on?
Oh, she can't.
So she's on an iPhone. Oh my God. The thing is, this is really, really, really important testimony. And it's one thing if just we can't hear it, but apparently even Judge Kite is having trouble hearing it. So I would imagine they're going to do something if she can't hear it. This useless people. I'm going to jump forward until we can hear something.
If you were using in 2023, was that the same number that you utilized in 2016?
Okay, here's the thing. So whatever happens in this is really, we will hear, it will be made reference to whenever they argue. So I'm going to go ahead because this is really kind of pointless. Let's just see if it changes at all. I mean, it's apparently, I guess they can hear her in court. It must just be wherever the speakers are. And then the camera is pointing at the TV. And I guess the speakers are probably not where the screen is. So that would be my guess. This is so sorry.
Sit down.
Okay.
The very first part of her answer, I could not understand.
Yeah.
Yes. I got that her husband is African American, something about the Mormon church, underworld. Can shorter questions and answers, I think, would be helpful because I can't understand it.
Thank you, Judge Kite.
Yes. I believe you were married to.
Beautiful courtroom, I will say, though.
And then sometime prior to July 2016.
Now we have the ceiling. This is so crazy. I wonder if this. Oh, that's the camera. No, that's her phone. I think she's never used Zoom before. Because we're looking at her ceiling. Okay, I'm going forward. This is crazy. Great.
Do you want her excused?
Okay, next witness. Kim Jensen, please, for the love of God, be in person. I would imagine she will be. Please. Oh my God. Oh my God. Oh my God. Is she in person?
Like, if you could get me a copy of it.
I'm going to leave it on. Here we go. Oh my God. I cannot believe this. Here she is.
Ma'am, you solemnly swear to affirm that
Wow.
testimony will be the truth, the whole truth, and nothing but the truth, so help you God.
Wow. Oh God, she's in person.
Mr. Bias, why don't you?
Sure.
Wow. 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 The alleged co-conspirator that the state never charged.
There's a lever beside me just to see.
Wow.
If you hear yourself over the speakers, everyone in the room can hear you. Okay.
We are going to get all the tea, people. Why is it being weird again?
Good morning, ma'am.
Good morning.
Has the witness been sworn?
Yes.
Okay. Will you please
Okay.
introduce yourself to the court? State your name.
Kim Jensen,
And how old are you?
54,
Where do you currently reside?
Jacksonville, Florida.
Okay. And are you currently employed?
No.
Okay. So are you a homemaker?
Hey.
Yes.
All right. How do you know Shanna Gardner?
This is a big moment. This is Kim Jensen. Let me just, for anyone, just to reiterate, this is Mr. Baez questioning her. This is Kim Jensen. This is Kimmy, the mysterious Kimmy who had all the text messages with Shanna, where both of them were joking back and forth about killing people. And the state has called her a co-conspirator. They interrogated her. She's never been charged. She reached out to the defense and said, hey, they're misrepresenting my statements. This is not accurate. I can't even believe that. Now we're going to hear from her. Wow.
I met Shanna when she and Jared moved here from Connecticut, probably 10 years ago.
Can you speak up a little bit?
Sure. I met her
I
at
can hear
church
her
when
fine.
she and Jared moved to Florida from Connecticut close to 10 years ago, 9 years ago.
And did you know Jared Brightigan prior to knowing Shanna Gardner?
His family attended in our congregation, so I did know him.
Okay. And when you met Shanna Gardner, what kind of a relationship did you develop with Shanna Gardner?
Shanna and I became fast friends. She had been assigned to visit me each month in a program at the church where sisters would look out for a handful of sisters, and she had been assigned to me. And so we bonded over things like We both had a twin pregnancy. We both had a horrible pregnancy. And we just, you know, she was actually in the youth program, and she was working with one of my daughters. And so she and I just became fast friends.
Okay. And are there other friends or a small group of friends that you have that you share in common with Shanna Gardner?
There are.
Okay. And are these other individuals from your church?
They are.
Okay. And is there a nickname that is given to you guys that you use for this group of friends?
The Lunch Bunch.
Okay. And who came up with that name?
It might have been me. I don't really.
Okay.
There was 8 of us, so I can't really. I really don't remember. We've been friends a long time.
Okay. And as part of, I'm assuming that as part of this bunch, you guys go to lunch. Is that correct?
We do lunch, brunch, breakfast. You know.
Okay. And how would you describe the conversations that occur within this group of friends?
Wow.
It was a safe place. We could talk about anything. We could be raw. We could be real. We could, you know, not have to be politically correct. If anyone was struggling with, you know, one thing or another, we could talk about it and, you know, share ideas, thoughts, whatever. And just, it was just a safe place.
And
like
when
judge each other.
one of you when a member of this group was going through marital issues, was that often shared within the group?
Oh, yeah.
Okay. And would off-color jokes or certain statements that you might not.
So what I think I'm hearing now, so that's a group. It's not just the 2 of them. It's a group. So it sounds like it's like they could vent about their husbands, right? Or their kids, or being annoyed. And that does sound like a lot of what we heard when they made the jokes about, you know, if my internet doesn't come back, I'm going to kill somebody, or I'm going to kill the Enterprise guy, or, you know, my kids or whatever. So I feel like I've seen this on certain like TV shows, you know, where people like have that, like the mom group, and they just like complain about shit. But like, I guess it sounds like this is kind of what's going on, but like this is in real life, maybe.
Say in public, were they made in reference to another member of the Lunch Bunch's husbands? I'm trying to get to.
Oh, sure. There were more than one person that was going through a divorce at the time. Some of them were ugly. Some of them were not so ugly. You know what I mean? But, you know, we've got your back kind of a thing. We were very connected and very, I guess, just always looking for things we could do to help the other person and make things a little easier.
Who was the one person in this group that probably was a little looser with the tongue, for lack of a better phrase?
Probably me.
Okay. Now, tell us, let me actually get a little closer to where we're at. Did Shanna confide in you a lot of the issues she was having with her marriage with Jared?
Yes.
Okay. And did you guys give him a nickname?
Yes.
Okay. And what was that nickname?
Stupid.
Okay. And were you someone that Shanna would joke with when criticizing Jared?
Yes.
Okay. And were you also someone that she would confide in as to her feelings?
Yes.
Okay. And how would you handle that type of information? You know, what would you do as a friend when she's venting or speaking poorly about her husband?
So early on, before she was divorced,
right.
I mean, it really just depended on the day. Shanna would, you know, back then, I mean, it was a long time ago. I mean, we would joke about things. We would joke about things that, you know, in any other setting wouldn't even matter. And, you know, we shared pretty much, you know, we shared a lot of things, like everything.
Okay. And what were things like for Shanna when the marriage ended?
When it ended and she was actually divorced.
Correct.
It was very difficult. Why was it very difficult? Well, prior to the divorce, their financial situation was an educational stipend that was given by their family. And Jared was in school. And when the marriage ended, that stipend ended.
When you say their family, whose family?
Shanna's family.
Okay.
Shanna's family provided a generous educational stipend that was utilized while he was in school. And when she got divorced, that ended. And at that time, Shanna had chosen to leave the church, and that caused a lot of hurt for her family. And so financially, she was kind of on her own, and she had 3 jobs. And,
okay.
You know,
okay.
This
couple things. Well, I have it paused. One thing that we didn't get to hear because we couldn't hear Susan Lee at all is didn't get to hear them ask her a question about, did you ever go looking for a hitman? Was that a joke? You know, we didn't get to hear about that. However, I'm sure that will come up with Kimmy, and I'm sure it'll come up later with argument, but that would have been the thing to know, like, did you actually go try to get a hitman, right? That type of thing. I would imagine the answer is no, or the defense would not have called her. And I would imagine she said it was a joke. But this is important because what have I said this whole time? I've said, I feel like it's weird that they keep bringing up the Mormonism because it's like, is it an issue? Is it not an issue? Those of us who followed other cases where Mormonism is a part of it, it's like, it's a big part of it, right? And I kept thinking there's more, I said as much, there's gotta be more to it, right? And same thing with the finances, right? Because I was confused because I was like, she has all the money in the world. This whole thing doesn't make any sense, blah, blah. The part we didn't know until now is that Shanna left the church. I know from knowing people who are in the Mormon faith, and also from following trials, but I know people like directly where that is huge. In fact, it's really hard to do. And as soon as she said that, before I think I paused to be like, I already know her family would have cut her off. That's what they do. And that's why they make it so hard to leave. And when I say cut her off, right, what will happen is they're going to cut you off in every way. And because she was reliant on them financially, I guarantee you it was that. But not just that. I would imagine usually it's like if you leave the church and your family's still in it, you're like excommunicated. Like you don't exist type of thing. Okay. And that's why it's so hard for people to leave. That adds a lot of context to this in a lot of ways. So I just wanted to point that out.
This whole new transition with the children of
big deal.
At that time, I think it was like
her whole world would have been completely upside down at that point. I can't believe we didn't know that. And I also just find that it's crazy. And I wonder what will happen next because it seems like they're back supporting her. Anyway, we'll find out. But I wonder if she left and came back because I've heard a lot of stories like that where people leave and they can't make it on their own, whether it's financially, emotionally, socially, the community. They make it so hard that oftentimes people will leave and come back. I wonder if that's what happened.
2 days, 3 days, 2 days. It was just, the math was worked out to where every other weekend, one or the other parent had them for the full weekend. So one day you might have them, whatever, however it worked out.
And then subsequent to that, did things change when she met? Take us through a little bit further in time. When did she actually meet Mario Fernandez?
I don't know.
The approximate, it doesn't have to.
A couple of years after she was divorced.
Okay. And then how did the situation change with Jared and communication with the kids and things like that?
I'm not sure I understood.
Sure. Can you give us a general description of how things progressed from that point on?
From the time she married Mario?
Yes. The relationship with Jared.
The relationship with Jared really never changed. It was always bad. Communication was bad because there was never verbal communication. It was all electronic. It was either text or email. So things were often misunderstood. And they were not good at co-parenting.
Okay. And did Shanna have issues with talking to Jared?
She would have preferred to pick up the phone and, but it was him. He was adamant that there would be no verbal contact.
Okay. Now, I want to take you to 2022. You were, were you close to Shanna when Jared was killed?
Our friendship?
Yes.
Yes.
Okay. And during this time, what was life, shortly after he was killed, what was life like for Shanna during that whole time?
Everything was focused on the kids, their well-being, their mental health, increasing therapy appointments, giving them, space to grieve and, just making sure she spent a lot of time talking with the guidance counselor at school. Everything was just focused on the children.
Okay. Prior to
Jared passing away, what was it already established that Mario Fernandez and Shanna Gardner were going to get a divorce?
Yes.
Okay. And what types of things were being planned out for that?
They had made a plan that I don't remember what month they actually told the kids they were getting divorced. But they had made a plan that they would let them know what was happening, but that they would continue living in the home together until school was out so that it wouldn't disrupt.
Okay. Now, did you cooperate with the investigation in this case?
Yes,
Okay. So when the police asked you to come to the police department and make a statement, did you do that?
I did.
And they sat you in a room and you had conversations with the detectives in this case?
Yes.
Okay. And subsequent to that, what type of contact did you have? Well, let me ask you this. How many times did they ask you to come in and talk to you?
The first time was, I don't know, 3 or 4 months after the murder. And then again, the following year in January, I think.
Okay. And then did there come a time where you were asked to testify before the grand jury?
Yes.
Okay. When was that?
February.
February.
Last year, 23.
Okay. And did you comply with the subpoena and go and testify?
I did.
Okay. And
So one thing
prior to going in,
is that February of 2023. So they got Henry Tenon. Let me double check. Just the timeline here. Hold on. So Henry Tenon. Oh my God, why? Hold on. Okay. Henry Tenon was arrested or charged on January 25th. So her testimony came after Henry Tenon was charged, but before Mario was charged, and of course before Shanna was, because Shanna was not charged until August of that year. So
to testify, did you have any contact with any of the prosecutors in this matter?
I did.
Okay. And who did you communicate with?
When I got there, I believe Ms. Stifler was the one that greeted me. And then they put me in a room and told me that I would be there until I was asked to come in. Mr. Mizrahi came in and spoke with me.
Okay. Before we get to that conversation, I want to ask you about this. What was your relationship like prior to the grand jury with law enforcement?
I didn't really have a relationship with them. I had talked to them twice. They said it was victimology. Used to say things like, you have the unique position of knowing Jared and Shanna and Mario. You know what I mean? Just, I didn't really think anything of it.
Was it ever contentious at any prior to the grand jury?
No.
Okay. What about your relationship with Ms. Stifler and Mr. Mizrahi? Was that ever contentious prior to the grand jury?
No, I didn't have a relationship with them prior to the grand jury.
Okay, so was that the first time you met them?
Okay.
Yes.
Okay.
So here's why I think that matters, because remember, like I keep saying, well, okay, the state has been calling her a co-conspirator, right? Why? They want, again, the state is in this position where they can't have both. They want to try to make it seem like Shanna was trying to plan for this all the way starting back in 2015, okay? The only way they can do that is by painting Kimmy as a co-conspirator and that all this was serious, right? And that Kimmy was really trying to help her solicit a hitman for a murder. And like I keep saying, I'm like, there's no way this is possible because she would have to be charged if they believed it, right? So the fact that, that's why he's asking these questions, right? The fact that her relationship with law enforcement was not contentious, right? That goes to show they didn't really believe that any of that was serious, right? Otherwise, like I said, if they really believed that, she would have to be charged. And it would be akin to Mario's involvement, right? Because if you're charging it the way they've been. Now, normally Mario, in most cases, would be charged usually as like the middleman, right? Like a Katie McBanois. Same with Kimmy. Kimmy tried to find somebody, allegedly, if it's true, right? If the text messages were true, tried to find somebody, reached out to Sue, right? But she's not charged with anything. And so that speaks to, again, does the state not really think that this was serious? Were they not really thinking that she committed any crime? Because if she didn't, then neither did Shanna, at least up until 2018. Now, what I'm wondering is what could happen here, right? I mean, what could happen here is if this all pans out the way it's looking, then what would happen is the state can't be using any of this, right? Of the text messages with Kimmy. They would only be able to use 2018 onward when she met Mario. And maybe they can still build a case with that. However, at this juncture, the vast majority of what they've presented revolves around, especially as it pertains to the premeditation, revolves around these text messages starting from 2015 to say she'd been plotting this for 9 years or however long, 7 years, something. And I said that's really unusual for someone to think about killing somebody for that long and not do it. You know what I mean? Like that seems weird. If she did it. But anyway, the state really wanted to bring that in because of these text messages. So it almost kind of seems like they don't really believe it, but they're like, this could look bad in front of a jury, so we want to bring it in. That's kind of what it looks like. So it'll be interesting to see what happens with this.
And then what occurred when, after you met Ms. Stifler and then you met Mr. Mizrahi?
Mr. Mizrahi, I was in the room alone. I was quite nervous. I didn't know what to expect. I'd never done anything like that. He came in the room, told me how important this was, that that they knew things that I didn't know they knew, that I was in a lot of trouble, that I had to tell the truth.
Let me stop you there. You said that you were, did you say he said you were in a lot of trouble?
Yes, that I could be in a lot of trouble from this. Gave me some statute about if you lie to a grand jury, you could go to jail for 30 years.
Oh my God. Threatening her.
It was very, I didn't go in feeling comfortable. How about that?
Okay, couple things. So this is a couple things to me. First of all, I even said this. I didn't know we would be hearing from her, but I kept saying, 100%, it looks like they threatened her, right? They threatened her. And again, to me, I'm like, but this doesn't make any sense because how come they didn't charge her? When you look at it this way, whether they were threatening her just to be mean or threatening her just to get her to talk or threatening her because they actually thought she was involved, what's clear is that after they talked to her, they did not charge her, which again speaks to me to say that, and now it kind of makes sense, right? That she explained the text messages, and whatever she said made them realize they didn't need to charge her. But again, the only way that can be true is if also it meant Shanna was joking. Can't have only one. So it does make it seem like they went in thinking one thing and then she came out and they thought a different thing, but then they continued on as if it was serious as it pertains to Shanna.
I didn't go in feeling comfortable. My nerves were like you know what I mean? I was very nervous. I didn't know what they were going to ask me. I didn't know why I was there specifically in relation to the murder because I didn't have anything to do with anything.
Okay. So why did you not go in there feeling comfortable?
Well, like I said, it was an uncomfortable situation, and I was made to feel more uncomfortable with, Mr. Mizrahi made me feel more uncomfortable. It was the tone, it was the, you know what I mean? I was scared. I'll be honest. I was scared going into this because I didn't know what was happening exactly.
Was his conversation with you one that he was just being informative, or was it more than that or different? Describe to us. I don't want to put words in your mouth. Tell us how you would describe his interaction with you.
Well, I mean, that was the basic interaction prior to going into the grand jury. Post, I went into a room yet again, and he told me that he knew it was uncomfortable. He thanked me for coming. He knew it was an uncomfortable situation, and that it was very intimidating, but that was his job because when you're uncomfortable, you say things that you wouldn't normally say, I think is how he put it.
Okay. Did he give himself a name to
No.
describe the situation of being uncomfortable? Or
he said that he used words like intimidation, and when you were intimidated and you're uncomfortable, you say things that you wouldn't normally say, and that's why it had to be that way.
Okay. So did you find it intimidating while he was questioning you before the grand jury?
I did. It was very frustrating.
Okay. Were you ever accused of lying or not being straightforward?
Yes.
Okay. How many times?
Maybe once or twice. I can't really remember.
Okay. And did you ever feel confused at any point in time?
Yes, because there was a constant hammering of they wanted to know exactly, when did this happen? When was this said? What, and I couldn't, I was nervous. My watch is going off for my heart rate. Like it was an uncomfortable day and it was a long day.
Wow.
Okay.
Wow.
So now let's fast forward a little bit to the next time you had contact with law enforcement and the prosecutors. When was that approximately?
Together or law enforcement, just by themselves?
Either one.
So the grand jury was in February, and in April, they had a search warrant for my phone.
Okay.
They took my phone and my watch in April.
And you gave those to them?
I did.
Okay. And then subsequent to that, when's the next contact you had with any one of them?
Next time was in July of last year.
Okay. And tell Judge Kite what happened in July of last year.
I was leaving my neighborhood and the officers were pulling in. I recognized the Explorer and I kind of saw him and I thought that it was Detective Johns. And so I pulled out of the neighborhood and they flipped around and followed me to the red light. And once I proceeded through the red light, they flipped their lights on. I pulled into the Publix parking lot and they told me that I needed to come with them to speak with the state attorney's office.
And were you free at the moment and fine and ready to go, or? I
was not. I told them I wasn't actually dressed appropriately. I was actually headed to the gym. They told me it didn't matter. They needed to speak with me now, and that they were going to drive me there and bring me back to my car as soon as I was done. And I said, that I wasn't comfortable with that. I asked to call my husband. I did. He's like, why would you ride with them? He's like, are you under arrest for something? And I asked him and he said, oh no, we're going to leave your car here. You're going to come with us. I'll drive you there, drive you back. And I said, I'm going to drive my own car. And he gave me a whole big spiel about parking and how difficult it was and that he had a subpoena that he didn't want to use, but that he would. It was an arsenal in his, or a tool.
This is insane. This is insane. This is insane.
In his arsenal or something to that effect.
Oh my God. Dude.
And so I said, well, if that's what you have to do.
It sounds like a movie when they, like with spy shit or something. Like, this is crazy.
So he gave me the subpoena and, then he told me that it had to be, he was going to get in front of me. He was going to be the lead car. And,
oh my God.
Then the other car was sandwiched in, we're doing the OJ Simpson thing going down the freeway. And we end up here.
Wow.
Okay. And what occurred when you got to the state attorney's office?
Not okay.
Where did you go?
I was in a conference room, or I was put in a conference room. There were blown up text messages.
Let me stop you there.
Wow.
Okay. You're put into a conference.
We had more than one interrogation. Now we're getting to the big interrogation that we heard about, but there was wow. Okay. This is the second one.
Yes.
Correct?
Yes.
And who was in the conference room with you when they brought you up to the conference room?
Nobody. I was put in the conference room alone.
But what did you see while you were alone in the conference room?
So it was a long table. I was sitting at it, and there was several blown up text messages between me and probably, I want to say 3, 4, I don't know, between me and the girls.
When you say blown up, how big?
I don't know. Like half a poster? I don't know, maybe.
Half a poster size? Okay.
Maybe. I mean, big enough that you could see it without, squinting. And then there was another board there's like a board on the side that had a picture of Shanna and Mario and Henry Tenon and me on there.
And what did it say?
I think it said something like conspirators or conspiracy to murder or co-conspirators, maybe it said. It's like it was done in a circle. Like,
what was your reaction to seeing a poster at the state attorney's office with your photo alongside Henry Tenon, Shanna Gardner, and Mario Fernandez?
I was very taken back because I was very taken back. I couldn't imagine where they were going with this because, I was just Shanna's friend.
Okay. Tell Judge Kite what happened next.
Mr. Mizrahi came in, told me to take in the room and they would be there shortly. I don't know, I was in there by myself 15 or 20 minutes and I was just reviewing everything. And then the prosecutors came in and told, they said they were sit down, we were going to talk to questions. And Mr. Mizrahi asked me if I knew why I was there. And I said, detective said you had some questions. And he said that the police wanted to arrest me and take me to jail.
Okay. And were the police there right in that room? Who was in the room alone?
Not at that time. I was just in there with Mr. Mizrahi, Ms. Stifler, and I think there was someone else.
Okay. Was that another member of the state's attorney's office? Do you know?
I guess. I don't know.
And after he told you that the police wanted to arrest you, how did you react? What did you say? What?
I said, for what?
Okay. And what happened after that?
It was another series of questions. They showed me that, the text messages were there and, this is pretty damning. This doesn't look good.
Let me stop you there. So they began to question you about your text messages?
Yes.
Okay. And while you're giving answers to your responses to these text messages, did you ever see a recording device?
No.
Did you believe you were being recorded?
I mean, I really didn't think about that, to be honest. You know what I mean? Like, I knew that when I spoke with the police that, you know what I mean, they would have a transcript or whatever. I mean, I really didn't know what their setup was. I guess it was possible, but I'm not sure that I really thought about that.
And did you write down your answers to the questions that they were asking you about your text messages?
No.
And if there's a dispute about what you said between
This is what I was
in response to the questions about the text messages, was there anyone else other than you and the 3 members of the state attorney's office? Is there anybody else there that would be able to verify that?
I mean, we were the only ones in the room, so no.
Okay. And then what happened next?
They asked me about the text messages, and and the text messages, and then additional questions that they asked.
Okay. What happened after that? How long did that last, actually?
I don't know. I think I got in there around 8:30 or 9 o'clock, and I don't think I left till after 1.
Okay.
Because I had an appointment at 12:30 that I missed. So I know it was after 1 or 1:30 before I left.
So what I mean is, how long were you alone in the room with the prosecutors?
Couple, 3 hours maybe.
Okay. And during that time, was it a friendly conversation? Was it contentious? Describe, take us into that room if you can, and describe the conversations between you and the prosecutors.
At times it had gotten very contentious. They got very frustrated with me.
Wow.
I'm trying to recall I can't remember the order, but there were questions about the text messages, and I would try to explain, like, for example, the one,
oh boy,
the one was,
We'll get into the specifics in a moment. I'm just trying to get a little bit more of the atmosphere.
Right.
So at what point did the police come into the room?
Police didn't come in until probably maybe an hour before I was able to leave. It might have been a little longer than that, but they called it a roundup, that they wanted to go over everything and all the questions that they had asked me and have them be able to participate and hear what we had talked about, I guess.
Okay. Was it
summary.
word for word or not?
No, it was like a summary.
Okay.
It was like a summary.
Got it. And was it as detailed as you had gone over with the prosecutors or not?
Some things were, I guess, maybe. Not everything. I mean, it was more of a summary. It wasn't, I was in there with them for over 3 hours, you know what I mean? And so no, it wasn't as detailed.
Okay. Now, subsequent to that happening, did you have any other interactions with law enforcement? Subsequent to the July meeting at the prosecutor's office? When's the next time you saw someone from the prosecution team or law enforcement?
Well, today's the first time I'm seeing the prosecution team since the July meeting. And law enforcement, I only had one other encounter with them. They came to my home
remember
the week in May
this was
of
in
this
July.
year,
Shannon was
before the hearing that was in May.
So before the Arthur hearing,
Yes.
they came to your house?
Yes.
How many days before the Arthur hearing?
I don't know, I think they came on a Friday, and I'm not sure what day of the week that hearing was.
And did they tell you the purpose of their visit?
They did.
Which was?
They told me that the state had sent them. They wanted me to know that my name was going to be mentioned.
Oh my
in the hearing.
God.
And I
No
said,
wonder she
why?
watched it.
Like, I was confused. It was a
Wow.
bond hearing. I didn't really understand the purpose, I knew what a bond hearing is, but I didn't really understand why I would be relevant to that.
Wow.
And they said that it was a mini trial. And so my name would be brought up and they wanted me to know.
Oh my
Did
God.
they
Oh my God. Oh
try
my
to
God.
educate you a little bit more about what was going to occur?
No, they said it was a mini trial. And I said, and you're telling me that the state
Wow.
sent you here as a courtesy to me? And they said, yes, that the state wanted to make sure that I was happy and healthy and safe. And I said, why wouldn't I be safe? And they said, well, we don't have any credible intel that you're not, but if you don't feel safe in any way, if anyone's following you, if someone vandalizes your home or your cars, we want you to call us.
What?
And even though we're not in your jurisdiction, we'll work with the people who are to make sure that you're safe. And it was the oddest.
Did that concern you that the police were telling you you might not be safe?
Well, the whole conversation was odd, but that especially it gave me pause. Like, what do you know? Like, what, you know what I mean? Why would I be unsafe? It didn't make any sense to me.
Did they insinuate or tell you that whose fault it would be that your name was being mentioned?
They did. I said, I asked them, how involved is my name going to be in this? And they said that, that Shanna's attorneys had unsealed the grand jury, and that was their doing, not the state's doing, and that so testimony could be used from that, and
trying to throw Shanna's attorneys under the bus.
That that it was just a mini trial.
Did they make any negative statements about Shanna's defense?
Not just in general conversation. Detective Johns asked me if I had any questions at the end of this little conversation that we had. And I said I did. I said I wanted to know if they had any idea when this would actually end. When will there be a trial?
I just wanted to point out that not only did Detective Johns lie about speaking to her on the phone, he met with her in person at her house. This is crazy. This is crazy. Oh my God.
And Detective John said that it had been their hope that there would be a plea deal, but because of Shanna's choice of attorney, that all these motions would be filed and this would be drug out, and they didn't see it going to trial before the end of 25 or the beginning of 26.
Was he referring to Mr. Cox or myself, Mr. Grody? Oh,
he was referring to you. There was no Mr. Cox at that time. He said that you had the reputation of being a mudslinger.
Oh my God.
This would be everyone's fault except for Shanna's.
okay. And subsequent to that, what happened next? Did you watch the Arthur hearing?
Oh, I did.
Okay. And did you see Detective Johns testify during that hearing?
Oh my God. Can you imagine?
During that hearing, did you see the statements that were made in reference to you?
I did.
And how he characterized your statements?
I
did.
Okay.
Called her
I
a
want to kind of
co-conspirator.
go through some of those statements with you. Now, Detective Johns stated to you, well, okay, look, I'm sorry, strike that. When Detective Johns stated that well, first I wanted to talk about Susan Lee.
Okay.
Okay. I'm sorry.
Yay.
Before I get to the Arthur hearing, I wanted to ask you about the meeting with the prosecutors. When they confronted you with the text messages about Susan Lee, what did you tell them?
Waiting for. This is what I'm waiting for.
I told him it was a long-standing inside joke.
Okay. Explain that. Why is it a joke?
So the Hitman joke was a joke between Susan and I years before I even knew Shanna. Susan used to, and I've known Shanna, I've known Susan for 25 years. So we've got a lot of history and a lot of inside jokes, but Susan worked for a member of the church who employed lots and lots of people. And she was his personal assistant, executive assistant, I don't know what her title was, but anyway, some years, probably 20 years ago, he asked her if her husband knew any hitmen, and she was taken back. And, when she got off work, the first thing she did was call me and say, "You won't believe what he asked me." And it became this just anytime we heard the word, anytime, I mean, it could be watching a TV show, it could be in any context, it would elicit a phone call, a text, whatever, because we were laughing about it, did he seriously think that her husband actually
But no hitman.
know a hitman? You know what I mean? Anyway, so it was that kind of a thing that just, so anytime we had the opportunity and heard about it.
Was Miss Stifler present when you gave this explanation? Or did she walk out of the room at any point in time? She didn't. I'm just curious if she missed that explanation of the joke.
No, nobody walked out of the room.
Okay. And what was their response after you explained this joke?
I think Mr. Mizrahi said something like, so you're telling me that the next time I see you, it's going to be with your attorney and you're going to explain to a jury that this is a joke, or something to the effect that it was ridiculous for me to say that these things were a joke when in fact it actually was. And the joke had nothing to do with Shanna. And it was years before I even met Shanna that, you know what I mean? I mean, I understand that the word sounds bad, but in the context that it was something that we had joked about for many years before I even knew Shanna.
Okay. So when you heard Detective Johns describing those text messages, did you hear him describe what your explanation to those texts were?
No.
Okay. Did you feel he gave an accurate description about those text messages as it related to Susan Lee finding a hitman for Shanna?
Absolutely not.
Okay. So would you characterize those statements as false or true?
I would characterize them as false in that the context was, I mean, the statements were there in print, but they were being inserted into a theory and not in the context that they actually occurred.
Okay. Now, is there anything else you could tell Judge Kite about those text messages or your explanation to the prosecutors and the police as to what they actually meant? Is there anything more light you could shed on that issue?
As far as the one between Susan and I?
Yeah.
I don't think so.
Let me ask you this question because I think it might come up. Did you have, after the Arthur hearing, did you have any contact with Susan Lee?
No, I have not spoken with Susan.
Okay, so the two of you never spoke and said, hey, wasn't that crazy or anything like that?
I've not spoken to Susan. I have intentionally distanced myself from anyone who might be on a text message that had anything to do with anything to try to keep the circle as small as possible instead of dragging more people into a mess.
And when you saw Detective Johns mischaracterizing what you said in those text messages, did that concern you? What was your reaction to that?
It was concerning because the way that he was portraying me, it was if I was involved in something that is completely untrue. I was not involved in any part of any of this. I was frustrated in that, I had tried to explain things and, clearly they weren't explained in a way that I felt like he was taking information from two years worth of whatever interviews or whatever from multiple people. And I felt as though some of them weren't even my words. They were just kind of mushed into his testimony, like he was trying to go from memory on all of these things. And some things were inaccurate.
All right, we're going to go over those individually in a moment, but let me just ask you outright. Did you ever contact Susan Lee on behalf of Shanna Gardner to try and get her husband to find a hitman for Shanna Gardner?
I did not.
Okay. Was that even remotely your intent when you were texting her about her husband?
Absolutely not.
Okay. And was it just simply a joke?
It was simply a joke that had nothing to do with Shanna.
Okay. Then why did you, I'm just kind of curious, then why did you say Shanna needs a guy and then mentioned about a magician and all that?
Because Susan's role in our little friend group and in the church, Susan was in charge of the women's group. It's called the Relief Society. She had stewardship over all of the women in the church. And so she had an interest in Shanna. She was part of my group, my friend group. So she had intimate knowledge of Shanna and Jared and their marital issues and then the divorce. And she moved away at some point. I can't remember what year she moved, but she moved away, and she would often contact me and say, how's it going? And I was like, oh, things are going good this week. Nothing really happened. Or, oh, it's one of those weeks. She needs a guy. And I would say it in that way, just so that she knew it was a bad week. And that's just how I spoke to her. That's just how I spoke to her.
Now, when Detective John stated that there were multiple conversations over a multi-year period about Mario killing or finding people to kill Jared, please explain to Judge Kite why that statement is false. Did you hear that statement? Actually, I should ask you first.
I heard the statement.
Okay. Was it true or false?
False.
Explain to Judge Kite why that statement was false.
Because I did not say that Mario was going to kill anyone. I was trying to explain, and I believe this all began in the grand jury. Am I allowed to say that? Am I allowed to say something that was said there?
If you can leave.
Your Honor, that's not correct. The state keeps saying this is unsealed. There's a very clear Florida statute on point that I believe the state even violated by showing the grand jury to Detective Johns. And your order only released it to the defense team, our lawyers and staff.
Hold on. Let me see all at sidebar, okay?
Oh boy. Okay, we're gonna go through. Wow. Okay, hold on. Let me go past the sidebar. Wow. He does not look happy. He does not look happy.
Oh, sorry. I know better.
May proceed.
Okay. Ms. Jensen, if we can avoid talking about what you actually said at the grand jury, let's try that, okay? If you feel you can avoid it with your answer, we'll take a break and figure that out, okay? So let me go back and ask you.
Well, do you understand what he's saying to you?
Not to repeat specific things that were discussed in the grand jury. There are several pieces of this that were discussed in multiple places.
Question.
Yes.
Do you understand what he said to you? Yes or no?
Yes.
Okay, go ahead.
Okay. So let's go back to the question or the issue at hand. Detective Johns testified that there were multiple conversations over a multi-year period about Mario killing people or finding people to kill Jared. Excuse me, about Mario killing Jared or finding people to kill Jared. Please explain to us why that statement is false. Why you did not tell them that.
The reason that it is false is because through interviews with both the prosecution and the police department, they asked me questions about Mario. I told them that Mario had a very large personality. He was famous for shock value statements, and that he had this one particular line that he would say repeatedly, which is, do you want me to take care of it? Or do you want me to take care of him? Do you want me to take care of it? And that could be anything. It could be from a kid on the playground with one of the kids. It could be him overhearing a conversation between Shanna and I. He said it to me about my daughter was having an issue with somebody in college, and he said, do you want me to take care of it? It was just, that was his phrase. And I believe it was Miss Stifler who said, you mean kill him? But those were her words. Those were not my words. I never said kill him.
When she said, you mean kill him, what was your response to that question or that statement?
I don't remember what my response was, but probably no. I mean, that's what he said. Take care of him. I don't know that there was a lot of.
And did you explain to the prosecutors and law enforcement that that was just a catchphrase of his and that essentially didn't mean anything to you?
Right. It came out. I mean, he was a big talker. He was full of it all the time. And I never believed anything he said. And it was never, I never felt that he ever said those words with the intent of harming anyone.
So if there are children playing in a playground and you use that as an example, explain to us how he would say, you want me to take care of it? Tell me about how that catchphrase coordinates with something completely different than murdering someone.
So if the kids came home and said, so-and-so on the playground was bothering me or picking on me or whatever, his line would be, you want me to take care of it? And he was famous for, there was a group chat between both households with both sets of parents. And he always loved to be the first one to answer no matter what the context was. And, and Shanna would always get upset with him and say, don't, just don't. And it just, so as far as the playground goes, I mean, it's just, there was a kid bothering one of Shanna's kids and, we take care of it. And it was like, no, I got it. We're good. So it was just, that was just an example of how it was used in all areas. That was just like his phrase.
You didn't understand it to mean he was going to go kill one of the kids, did you?
No.
Okay. Now, I want to move on to another statement by Detective Johns. Now, he testified that you made a statement about Mario having a motorcycle gang go and kill Jared. Or, well, there's two parts to that question I want to ask you, but let's start with the motorcycle gang. Tell Judge Kite, was that an accurate statement? And if not, why is that false?
In one of the questions that I was asked about Mario, I had told them that he made shock value statements, and one of them, and they said, "Can you give us an example?" And I said, "Well, I think one time he said that there was a motorcycle gang that met behind Jared and Kirsten's home, and it just was, it just seemed ridiculous to me. It was a brand new neighborhood."
Are you familiar with where Jared lives?
I know where they live.
And based on the fact that you're familiar with that area, did you take the fact, how was your reaction to him knowing a motorcycle gang?
It was something that he had said to Shanna, and I was just like, are you kidding me? He's so, he's just, everything he says is so, it was just another ridiculous statement.
And did you express that to the prosecutors and law enforcement?
I did. I think I even discussed how it was a brand new neighborhood, and I struggled to believe that a motorcycle gang was meeting there.
Now, again, did you believe that while you're answering these questions on a murder case with the prosecutors and the police, that you were being recorded, that hopefully your answers were being accurately taken down?
In hindsight, I guess it was an assumption, but I don't think I gave that much thought. I was just there, let me answer your questions and leave. Like, you know what I mean? I didn't give it a lot of thought.
Okay. Now, the next statement by Detective Johns was that Mario was so close to Jared that he could reach out and kill him or touch him or something along those lines. Do you recall that line of testimony?
I do recall the line of testimony.
Okay. Was that true or false?
That was another example of a shock value statement that he said. I don't think it was ever Mario. It was always, he has eyes everywhere kind of a thing. That, Shanna never needed to worry about the safety of the children when they weren't with them, that he had eyes everywhere. And he said, but it always toggled off of something that the children would have said first. And then maybe a statement was made, hours or days later from him. Maybe the kid said, "Oh, Dad went to a meeting, so, somewhere or something." And they would say, and then it was like, "Well, oh yeah, there was someone so close to him, they could have touched him."
When he said he has eyes everywhere, was that in the context of he could keep Shanna safe from anyone, not necessarily Jared, or I'm a little confused on that.
He just led Shanna to believe that he had eyes everywhere. Like, you don't have to worry about anything. I've got eyes everywhere, kind of a thing. Like, it was the general feeling he wanted her to feel safe.
Is that what you meant when you responded to the prosecutors and Detective Johns, and not the fact that he was following him or was going to the point where he could kill him?
Yeah.
Okay. Now, I want to ask you about another line of questioning, or another line of his testimony. Did you hear the testimony about Detective Johns saying that you said Mario described these as missed opportunities, being, I guess, following him and them being missed opportunities? Did you hear him make those statements in the Arthur hearing?
I did. I heard the whole hearing, so I did hear the statements.
And did you ever say that to Detective Johns or to the prosecutors?
I don't recall the context of that statement. Like, I don't remember that particular statement as.
Did you ever make that statement? This is my question.
I don't recall that particular question of, when that statement, I was trying to think of where that one came from, and I don't remember.
Okay. Do you believe you even said or made that statement about missed opportunities? Does that sound like something you would say?
Depending on the question, I guess it's possible, but I don't think so, but I don't remember.
Let me ask it a little more clear if I can. In the context of Mario having the ability to kill Jared and describing them as missed opportunities, did you ever describe anything remotely like that to the prosecutors?
I don't believe so. No.
Okay. And of course, No, I'll strike that. The next area that I want to cover with you is about this. Did you about the testimony? Detective Johns testified about there being some delay of killing Jared because of COVID. Tell Judge Kite why that statement is false.
I never said anything about a delay in killing Jared because I never had any knowledge of Jared being killed or a plan to kill him. Again, the children had come home from a week at the other household and had told Shanna that Jared was working from home, that he got a different job and he was working from home. Not long after that, Mario had made a statement that he never goes anywhere. Well, neither did anyone else in COVID. Like, it just didn't seem like, you know what I mean? Like, it.
But was that statement in reference to going to try and kill him, or?
No, it was just in general as the whole, you know, I know where he is at all times kind of a thing. I know where everybody's, I've got eyes. Not necessarily mine, just eyes.
Okay. And I guess what I'm getting at, and I want to be clear because we don't know exactly what you said in that room. So I want to be clear about this question. Did any of that have anything to do with Mario having any animosity or intent to harm Jared in any way, shape, or form?
Mario didn't like Jared at all. Mario said oftentimes that, you know.
But I want you to answer my question if you can. Yeah. The statements surrounding the fact that he didn't go anywhere.
Right.
Was that in reference to him attempting to go kill him or anything like that, or cause him harm in any way, shape, or form? Or was that just Mario talking about Jared in a general way?
I would say it was just Mario speak, his grandiose shock value statements that he always says, depending on why he was making them. You know, was it a bad week on text? Was it you know, it would just depend on the day.
All right. The next question I want to ask you is in reference to the testimony that Detective John said. You said during this meeting that Shanna knew of Henry Tenon before he was arrested. Was that true?
That can you say the question again?
Yes. Detective Johns testified that there were conversations between you and Shanna about Henry Tenon before Henry Tenon was arrested. Was that a true statement?
The problem is, in retrospect.
And when I say arrested, I'm referring to being arrested for murder.
Right.
Prior to that.
Right. So this is where the disconnect is. And I think part of it might have been my fault with the prosecution. I never knew who Henry Tenon was by name or any, I didn't know who he was until that arrest. I had a conversation with Shanna in the fall after Jared had been killed. She was just telling me that Mario, it was a conversation about Mario, and she said that a guy that lived in the downtown house had been arrested. I never knew his name. I didn't put all the pieces together of who he was until after that was announced and the news started advertising that it was a tenant, which I think that his last name and tenant were maybe caused some muddied waters.
So you never knew who Henry Tenon was until it was announced he was being charged with the murder case?
Not at all.
Okay. So any statements by Detective Johns that those that you knew would be false?
They would be false because a lot of times I was answering questions after the fact. So at that point, I knew who he was, but prior to that, I did not. And I'm not sure that I ever made that as clear as I should have, because listening to some of the statements that Detective Johns made, it was obvious that he thought I knew who he was before I actually knew who he was.
Okay. Now I want to ask you about Detective Johns testifying about a week before the murder and this Hawaii trip. Are you familiar with that testimony?
Yes.
Okay. Now, was this another situation where, was this a statement of take care of, Was this a statement with Mario Fernandez making a claim that he would take care of that or something like that? His famous catchphrase, so to speak.
It was.
Okay. Describe for Judge Kite exactly what that was about, that conversation, what you told them.
Shanna had called me and told me that they had decided to get divorced. And Mario said, do you want me to take care of him? Or do you want me to take care of him? You know, I don't know him, I'm not really sure. And she said, Jared, and he said, yes. And she said, absolutely not. She said, I choose you. And that was the whole conversation.
Okay. When you say I choose you, was she referring that she was going to try and stay with Mario, or what? What does that mean?
No, because I'm not, and that was something that I tried to explain was I'm not sure. They went to Hawaii at least once a year. Sometimes it was twice, but it was at least once. And typically it was an evaluation of, I mean, it was a trip, but they would always like evaluate their marriage. They had different parenting styles. There was obviously, you know, things were not perfect. And so they would evaluate whether or not they were going to stay married. And so I don't recall if it was that particular trip or the one, you know, another one. I just know, I know that it happened. That conversation happened on a Hawaii trip, which one I wasn't sure.
Okay. And
Interesting.
why aren't you sure?
Huh.
Because Shannon and I talked a lot.
Okay. Now, then when you also, without getting into what you said before the grand jury, actually, I'll strike that. I don't want to complicate that issue. Did you hear Detective Johns make this testify about Susan Lee changing her phone number?
It did.
Was that statement true and correct?
No.
Tell us why that's false.
Susan's had the same phone number for as long as I've ever known her, which is like 25 years.
Okay.
Even when she moved, she never changed it.
Now, did you ever explain the context of Mario's catchphrase with Detective Johns about take care of it?
Yes.
Okay. And how many times would you say you told him about that?
I don't know. I mean, I feel like that kind of came up multiple times over the course of.
Now, we also saw numerous text messages going back as far as, I believe it's 2016, about a hitman. What did you tell them about those texts?
That it was an inside joke between Susan and I and didn't have anything to do with Shanna.
Even when Shanna would say, I'm not joking?
Yes.
Okay.
Well, that was 9 years ago too. I mean.
I'm sorry?
So that was like 9 years ago.
Okay. What's the context? We saw text messages about funeral potatoes or casseroles. Can you tell us what was the purpose of that? What's the story behind that? Well, first, let me ask you this. Did you tell, when those text messages came up during the meeting with the prosecutors and the police, did you tell them what that was about?
Yes.
Okay.
Yeah. They just are mischaracterizing everything you said, which is wild.
Tell us about that. What's the context of that? I don't understand that.
Well, the prosecutors were under the impression that that was a code word for planning a murder, which is patently false. Funeral potatoes is just like a little catchphrase in the church. It's like a staple food after a funeral. The people get served a meal, and typically it was that. At that time, back in 2015 or 16 or whenever it was, Susan was in charge of the women's group. I was part of the team that would help provide food for families who had lost loved ones. And I think I got asked to make funeral potatoes like 4 times in such a short amount of time. And so that kind of was like it was just a common thing at the time, because it was like, oh, more funeral potatoes. And, you know, so it's stupid is what it was.
In reviewing those text messages, Shanna says some pretty ugly things about Jared.
Yes.
And fair to say you did too?
Fair to say.
Okay. Why are you making these statements about Jared?
Because at that time, they were both single. During their marriage, Jared was very hands-off when it came to the twins. He didn't have a lot of interaction with them as far as taking care of their needs. And during the separation, prior to the divorce, and then for after the divorce, while he was just single, it was tossing the kids back and forth, 2 days, 3 days, whatever. Many times I would go with her to pick up the children. And the children would have gone to him on a Friday, and you're picking them up on Monday morning, and they were wearing the same clothes. They were 3. They'd had accidents. Their clothing had not been changed, even through the accidents. And
Let me stop you right there. I want to know really why you're sending these text messages that you would like to see him harmed too, or words to that effect.
because it was just more of a,
I'm objecting. This is well beyond the scope of the motion. We don't need to get into this. Broken things that are relevant.
Well, it's reference to her statements. Her text messages were admitted where her statements are being made. I'm just trying to get her to clarify those statements that are within the text messages or explain them.
The purpose of this hearing is not for witnesses to set that are bad mouth or deceased ad nauseam.
And that's why I'm trying to bring it back as to why she.
Okay, to that extent, I'll sustain the objection if you'll just rephrase it and get it back to, I guess, the context and not her personal opinions.
Give us the context of these text messages where both you and Shanna are talking badly about Jared.
it became obvious that the children their needs were not being met under his care.
Let me restrain. Let me stop you there. Would you? I want to try and leave. See if would you describe? Well, is it fair to say that the two of you were just venting your frustrations with Jared, right again, when you were sending these text messages back and forth?
Yes.
Okay. And were they ever serious in nature, or did you ever believe them to be true? Meaning, were they ever meant to harm Jared in any way? Were you serious about, I guess, poisoning him with lard and things like that? Were those statements and the negative back and forth between you and Shanna, were they ever did you ever take them to mean that you guys, or you, that there was any intent to harm Jared?
No.
Okay. Now, having said that, I want to ask you about another issue. Did Detective Johns ever confront you with issues that he had with the church?
He made it clear to me and to even others who were interviewed that he was not a fan of the church. He was not a fan. He didn't trust the church. He didn't trust the leadership, and questioned he had a whole series of questions about my feelings on when Shanna left the church and things like that.
Wow.
When you say he was not a fan of the church,
Well,
why do you think
how
that?
is that appropriate?
What's the relevance of this?
Detective Johns testified significantly about the church and other witnesses related to the church. I think his position as it relates to that church bears some relevance as to his credibility or his potential bias as a witness.
I agree, it does.
So, I mean, this has been months ago, but I recall, give me a moment.
He actually said, no, this is impeachment material. Sorry. She's going to find it. Detective Johns actually said that he had like little familiarity with the church or whatever, and this would go to impeaching him. Makes me wonder if maybe Detective Johns was a member of the church and left at some point, maybe.
I could withdraw the question. It's not.
Okay. All I remember him saying is something that he had to do research about the church.
Right.
I don't remember anything really beyond that.
Okay. If I can have just a moment, Judge.
Sure.
Impeachment material. I wonder if we're going to hear from Detective Johns again. And probably.
Ms. Jensen, the testimony you've given here today, have you given it to the best of your recollection?
Yes.
Okay. Now, have you had any medical issues that potentially could affect your memory or how you remember things, I guess?
I have.
Okay. What exactly occurred to you that, or what medical issue is there? Can you please tell Judge Kite?
A few years back, after a routine operation, I suffered a stroke and was in the hospital for several days, and it affected parts of my memory to where sometimes I jumble things. Sometimes I have a harder time with timelines than anything, chronologically, remembering exactly, when something happened or didn't happen.
And have you discussed this issue with your medical providers?
Yes.
Okay. And have you, is it your understanding that this is potentially because of the stroke?
It's absolutely because of the stroke.
Okay. Did you, at the time of the grand jury, and again, I don't want to get into your testimony, but at the time of the grand jury, did you advise the prosecutors about your stroke?
I did.
Okay. And the effects that it had on you?
I did.
Okay. And did that seem to sway them in any way, shape, or form in trying to get you to recall things?
Did that change them? What I'm trying to ask you is that, did they accept that as a response, or did you feel they accepted that as a answer as to why you couldn't recall things? No.
Okay. Why do you think that? I'll withdraw the question.
Okay.
That last question, of course. I have no further questions.
You intend to cross?
I do, you'll be brief.
Okay.
Good morning, Ms. Jensen.
Good morning.
Did anyone else in the lunch bunch, did any of those divorcees, were any of their husbands murdered?
Did they what?
Were any of the lunch bunch husbands that were getting divorced, were any of their husbands murdered?
No.
Okay. So this was a little bit unique. You would agree with that, right?
Sure.
Okay. I want to be clear, when Mr. Baez is going through all of the statements that I think you used, the catchphrases of Mario, those are coming from Ms. Gardner to you, correct?
Yes.
They're not coming from Mario to you, correct?
Some were.
Some were, but the ones about getting rid of Jared, the important ones, that's coming through Ms. Gardner, correct?
But again, you're putting words in my mouth. I never said getting rid of anyone.
Taking care of, the catchphrase.
Yeah, the catchphrase.
I'm just being clear because it's not at all clear on the record that it sounds like from the record that you're hearing all of these things directly from Mario, when in fact you're hearing them from Ms. Gardner. Not that you've never heard Mario boast about something.
Right.
The particular statements that Mr. Baez was referring to in his direct examination, those came through Ms. Gardner to you.
Predominantly.
I asked her about multiple areas. Can he be more specific?
Which ones came from her and which ones didn't? You want to go through each one of them? When he said he was going to take care of Jared, did you hear that from Mario's mouth, or did that come from Ms. Gardner?
From Shanna.
And did it come from Ms. Gardner when Mario told her about a biker gang that was hanging out behind the house?
No, that was from Shanna.
Yeah, and did it come from Ms. Gardner when he was talking about Mr. Bradigan wasn't going anywhere because of COVID?
From Shanna.
And that he could reach out and touch him. That was through Shanna, correct?
Well, that wasn't referring to him, but yes, Shanna.
No, but you're getting it from Shanna.
Yeah, this whole thing is like a bad game. Detective John said that, Kim said that, Shanna said that, Mario said that it's like a bad game of telephone. Like,
no
making my
kidding.
point for me. You don't know any idea what Mario is referring to other than what Shanna is telling you, correct? Don't look over there.
No, I'm just looking in general.
Wow.
Sure.
Holy crap.
You know what I mean? I'm not going to argue the point.
Okay, so the answer is yes.
Yes.
And your medical condition has not improved in the last couple of years. You're still in the same condition you were when you were interviewed by the detectives and appeared before the grand jury and spoke to the prosecutors, correct?
Yeah, I'm stable.
Right, so it's not like a year ago you were in terrible shape and now you're magically better. You're basically the same person you were over the last several years.
Yes.
Rude.
Thank you.
Rude.
You just said Mr. Mizrahi was putting words, or they were his words. And one of the questions he asked you was taking care of Jared. The statement was, do you want me to take care of it? Not, do you want me to take care of Jared, correct?
Correct.
Okay, I wanted to clear that up. Now, when Shanna told you about the motorcycle gang, did you guys laugh about it?
Yes.
Okay, were all of these statements that are described that we covered today, statements that the two of you were, for lack of a better phrase, ripping on Mario because he's saying all of these ridiculous things?
Yes.
And is that, were you able to convey that to the prosecutors and to law enforcement?
I thought I did. I told them that most of the things that he said were just ridiculous. That I feel like I was very clear in saying that I didn't believe much of anything that Mario said.
And now following up on the cross-examination, when you describe them that these are conversations coming from Shanna, they're in effect, are they basically in effect the two of you laughing about things Mario said?
Yes.
No further questions.
May this witness be excused? Thank you, Ms. Jensen. Mr. Baez or Mr. Crody?
We have
Yes, ma'am. Just one moment. Our defense will call Linda Luchetti.
I couldn't hear the name.
Sorry, Linda Luchetti.
Linda.
Good morning, Your Honor. Thank you for having your court today.
Hey.
Good morning.
Yes.
Ms. People, why don't you stand at the podium over there so she can see you, okay?
Oh, great. Another Zoom. I wonder if we'll be able to hear. Oh, boy.
Right, you may proceed.
Okay, we can't hear any of this, so let me go forward. This is silly. Sidebar, sidebar.
Members of the media, while we're getting reset up, I just make sure, like, try not to zoom in where you're getting portions of the attorney's computers, because
I agree with that.
obviously they have materials on there that wouldn't necessarily be public disclosure. Okay.
So they're going to be
so just make sure. Okay.
They're going to be getting into argument now, I believe. Oh, no, they're still on her. Okay, let me go forward. So the sidebar was about cameras. Yes, this is impossible. Let's go forward. Argument?
We tendered defense exhibit 3. It is a transcript of Detective Johns' entire testimony. There'll be references to that by the bias during the argument. And
all right, we're getting the argument.
Okay. All right, thank you.
And please accord.
Yes, thank you.
There are several issues, so I'm going to try my best to do it chronologically for the court, and hopefully it will certainly sound a lot more fluid if I do it that way. But I'd like to take and direct the court's attention to how we got to the Arthur hearing to begin with. Obviously, we had the issue for the prior motion to recuse the state's attorney's office that preceded the Arthur hearing. We had filed our motion for bond, and I understand the court and the state preferred that the court dispose of the disqualification issue first before we ended up addressing the Arthur hearing. It was something we pushed because obviously Ms. Gardner's freedom is at stake, in addition to the fact that her main concern is she currently has a child with a terminal condition. And even to this day, every single day away from that child is absolute torture for Ms. Gardner. Having said that, we got to the Arthur hearing, and one of the first issues we had prior to it even commencing were these text messages of Susan Lee. So we were straight focused from the very beginning on Ms. Lee. The state argued that these messages were relevant because of Ms. Gardner's attempts to incite and induce others to kill Jared Brightigan. that was raised multiple times during their argument. But I think what's important is that we go through the timeline of the testimony and see how, in fact, that argument doesn't seem quite right. First off, Detective Johns testified about finding these text messages between Kim Jensen and Susan Lee. And upon finding these text messages, which, knowing the context, we all know the context of this case and how those messages would seem to be incredibly damning information because they are the only ones where there's an actual solicit to another individual to hopefully find a hitman. Upon finding these texts, we now know that Detective Johns reached out and called Miss Lee on June 27th. Subsequent to that, we have the July meeting with Kim Jensen. So Miss Lee testified that she had a conversation with Detective Johns, and it was brief, and she had agreed to have a Zoom call with them at a later date. We now know that that conversation or that Zoom call never occurred. In addition to that, that communication with this witness was never documented anywhere, and we only found out about all of this at the Arthur hearing. We now find out, in addition to that, that in July, when Kim Jensen went in, she explained the context of these text messages and the joke about Miss Lee's husband being African-American and how it was something they teased her with, and it was an on-running joke. And as you heard Ms. Jensen today testify, that this is something that was a joke long before she even met Shanna. So that explains why the state, finding this incredible piece of evidence, never followed up and never had a Zoom call with Miss Lee, because they absolutely knew that these text messages were made of a joke. And in addition to that, that also explains perhaps why they didn't file any police reports in reference to the contact. It also explains the fact as to why Miss Susan Lee was never placed on the witness list for the state of Florida. It's quite shocking when you look at the context of this case that those things would occur with such a big piece of evidence. But as the facts unfold, and what was known to the state at the time, as early as July, was that these text messages were not going to be relevant to their case. But yet they came in here, they argued for them, and they argued specifically that this was an example of Miss Gardner attempting to solicit someone to kill her husband or her ex-husband. Then we get to Detective Johns' testimony. And if you could go to the next slide. I actually start with...
Mr. Bias, hold on.
Sure. And Judge, I'm not going to be reading or referencing the entire...
I can't see this on my screen for some reason. You want me to unplug it? All right, sorry about that.
Sure, no problem. I'd like to direct the court's attention to the last question on line 23. And for the record, it's page 41 of the bond hearing transcript, where the question is asked, and in your conversation with Ms. Jensen, she disclosed to you that she reached out to this person because of her conversations with Ms. Gardner. Answer, correct. Now, in the context of this would lead the court to believe that she had a conversation with Ms. Gardner about killing Jared Brightigan, and then she reached out to Susan Lee in an attempt to do so. But it completely omits the critical fact of what Ms. Jensen actually said these text messages signify. And to not advise the court of that is reckless. It's a clear attempt to mislead this court into thinking one incredibly damning fact that in fact is absolutely false and ended up being a joke and albeit an inappropriate joke, but this case is riddled with that type of off-color humor. But the timeline of how all these things occurred and the fact that they never placed her on as a witness and never advised us that she was a witness. Now, if we go through this discovery and we see these text messages, as a defense, we're going to be incredibly worried about the situation. And we would have, of course, the fact that they knew early on that these were a joke, we certainly would have liked to have had that information for the Arthur hearing so that we could have clarified for the court that this evidence isn't worth the paper it's written on. And to leave the court with that false impression that this was a legitimate solicitation for murder is befuddling, to say the least. So then we get to Detective Johns' actual testimony. When pressed on cross-examination, I asked him specifically, and if we go to the next slide. And this is, I would direct the court's attention to the paragraph on the right, the top question, where I asked Detective Johns, now you never spoke to Susan Lee, did you? And his answer is, I believe one of my colleagues did. That's a lie. We know that obviously from Susan Lee's testimony and how accurate she was in terms of being able to go back and look at her phone records. And subsequent to that, we also know that's a lie because after being pressed multiple times, if we could go to the next slide, where I come back to the issue and press, so you're the lead detective in this case, and you have text messages where they are allegedly looking for a hitman, and they call and they are texting someone. You got it right there in black and white, and you are texting a potential suitor for this hitman, and you never go and talk to the person who is the alleged person who they went to go looking for a hitman. His response now is, I believe at the time we were trying to locate her, her phone number had changed, and we didn't have a good address for her, so we were not able to contact her at the time during these messages, during the message. That doesn't make sense. But now, it wasn't one of his colleagues that spoke to her. She changed her number, and we also found that out to be false. So when you pull that all together of what Detective Johns did in his reckless disregard for the truth to try and convince this court that this was a legitimate search for an actual hitman, aside from the changing stories during cross-examination, he still stands with the benefit that neither the court or the defense know that Ms. Jensen had told them back in July of last year that this was in fact a joke. And they knew it was so much of a joke that they didn't even bother calling her or following up with her, but they still found it important enough to bring before the court as evidence.
The other question that this raises for me is with all this information coming out, they're not going to be able to bring any of this in at trial. It's interesting because, then what is their case? Because again, at the bond hearing, that was their chance to show Judge Kite. Remember, they even called it to her a mini trial. They called it to Kim. It's like, this is why you should hold her and keep her in detention, pretrial custody. And again, it's almost like them trying to show or needing to show how this charge is applicable and how, again, the presumption, what is it? The evidence great presumption, whatever the languaging was, we went over it earlier. So when you think about that, and that at the Arthur hearing, it was basically the vast majority of it was these text messages. If you remove all of that, what does this say about their case for trial, though? You know what I mean?
To restrict this woman from her freedom and to keep her away from her children during pretrial detention. I don't think any lie would be acceptable for any witness before the court, but for a detective, the lead detective, to do that in this case, on this issue, which is such a serious matter, which I presume was an important issue for the court when conducting its evaluation. My cross-examination was only as successful because I didn't have this information to perhaps paint Detective Johns as either sloppy, negligent, or not fully prepared, because that's the best I could do with the information that I had. I pressed him, he changed his story, but at the end of the day, this is...
So Flashman is asking if Judge Kite limited evidence. I think to the contrary, because at the beginning of that Arthur hearing, they actually said, and at the time they didn't know what was going to all be in these text messages, but they said, there was a hearsay objection. And the response to that was that the rules of evidence don't apply at that phase, right? This is a pretrial hearing, and that's true. The rules of evidence don't apply. So if anything, it's the opposite. If anything, it means you can bring in evidence that even you wouldn't be able to bring in at trial, right? but still, you would want to put your best evidence forward if you're the state, regardless of if it can come in at trial. You would want to put your best evidence forward, hearsay or not. You want to be you're presenting whatever is your strongest evidence. And so, while they might have been able to get some of that in, it kind of depends, right? Because there are exceptions to hearsay, but they didn't have to argue any of that because it was irrelevant. So in other words, like where we were at before, potentially maybe some of that could have come in. There could have been exceptions to the hearsay rule. However, I think at this juncture, I don't think the state can put any of this on because of the fact that there's too many problems with this. They would have to call Sue, they would have to call Kimmy, and I don't think the state's going to want to do that. However, the defense might want to call them. But I don't think the state, and again, like it was even brought up before, the state chose not to call them for that hearing for a reason, right? So.
Still a search for a hitman with Susan Lee's husband. It is not, I could not convince anyone otherwise because of the facts that these text messages look pretty damning. But yet, of course, as you know, both witnesses, both people who were actually behind the text messages were able to clear that matter up for the court and the defense at that point. But it wasn't until seeing this issue.
Think that, if I were the state, what I would say is let us try again and put on different evidence. But I don't think that's going to, in other words, this was their shot at their Arthur hearing to put on, again, their best evidence to try to keep her detained. And he's destroying all of it. So.
Where Susan Lee is actually watching this and realizing what a gross miscarriage of justice that this was. That she literally.
I'm arguing myself in my head. Having said that, there's still the checks, right? There's still the financial stuff, the checks, but that was the smallest portion of what the state put on. But if you're Judge Kite, you could maybe still use that. However, again, in her order, when she denied bond, the vast majority of the things she stated that she was making that decision based upon was, she said it, Kim's grand jury testimony and the statements and the text messages that she believed were not made in jest. So if you remove those, you're left with what did she say? Financial documents. That was the only other thing, was the financial documents that Judge Kite cited in her ruling.
They went out and hired a defense attorney and then had that defense attorney reach out to the defense and clear up the matter for the court. We don't usually have that benefit. And this is textbook lying and hiding the ball by Detective Johns. And the fact that the prosecutors were present during these questions is another matter altogether. Now, then that takes us to Linda Luchetti. Oh, if we can go up 2 slides.
Now
to the actual transcript.
We were not able to hear her, but we're going to hear things now.
Ms. Stifler
okay.
is questioning the witness at Mr. Detective Johns at this point and says, did you make attempts to speak with Christopher Thomas and Linda Luchetti and other members of the Intrepid Crisis Management Firm? Answer, myself and one of my colleagues flew in an attempt to speak with them and they avoided us.
This was really funny because I remember I poked fun at this because what Detective Johns said is that she was running around her house or whatever. I joked about it because I was like, that's so funny that she was running around her house to avoid speaking with them. So we could not hear Miss Luchetti's testimony because she was on Zoom, but it doesn't matter because he's gonna reference to whatever she said, and obviously, clearly, it's going to dispute what Detective Johns said. So, wow.
That as Miss Luchetti testified to today would cause serious doubt on that statement. Question: can you be more specific about your attempts to and their avoidance?
Right here.
Answer: well, Miss Luchetti was running frantically around the front of her house as to hide from me, so I couldn't see, and she was in her house. Mr. Thomas was not in the office. I went to his residence and he had his wife answer the door a couple of times to avoid speaking with me. Well, while we don't have Mr. Thomas's testimony, we certainly have Ms. Luchetti's testimony that this description of events was absolutely false.
Okay.
And she felt it was important enough to bring forward and come forward and actually advise the court that this detective was again attempting to mislead the court.
So she did the same thing as the other two. Wow. So she came forward on her own volition to say, hey, I saw the hearing and that's not true. That's what that sounds like. And again, we couldn't hear her because she was on Zoom and they don't have it to where you can hear it. But that is what he's saying, that she came forward to tell the court. So far, every single person that Detective Johns spoke about and said, here's what they did, here's what they said. So far, every single person except for the defendant, who has the right to remain silent, has came forward on their own volition and contacted the defense to say that's not true. Ruh-roh.
The fact of trying to avoid a witness is one thing. And then you have the fact that they actually they gave, the next slide, while in Utah, Detective Johns gives a Florida subpoena to a citizen in Utah, for which, as we know, this is not how it's done. And in addition to that, he has no authority to give a subpoena to a witness to appear in Utah. He has no such power. And then changes the date on it, as you can see, to a specific date and time for the next day, and then doesn't show. Never keeps his appointment with Miss Luchetti. So Detective Johns' characterization of that part of the testimony is completely false, and there's a reason why. And it takes us back to the issue of the truck. Detective Johns' attempt to discredit Miss Luchetti and her associate is kind of bootstrapping and covering up the main issue of what they attempted to do during the hearing, which was they specifically presented that on the night of Henry Tenon's arrest, that the next day there were a flurry of phone calls to this PR firm and to her attorneys. And as you know, and if we can go a couple of slides after the transcripts, here is the statement. And to be specific, this is Ms. Stifler's question on line 13. And to be specific, Ms. Jensen told you she had conversations with Shanna Gardner about Henry Tenon, and those conversations before or after Henry Tenon was charged with the murder of Jared Brightigan. Answer, those were before. Question, so before Henry Tenon was publicly named as an individual involved in the murder of Jared Brightigan, Shanna Gardner and Kim Jensen had discussions about him. That's correct. And they had these discussions about owning the truck. That was one of the areas where they tried to mislead you into thinking that Shanna Gardner knows that Henry Tenon's truck was used in the murder before anybody else knows. So she must be the mastermind behind all of this, because she knows about Henry Tenon and his truck being used in the murder before the police ever make it public during their investigation. But this is not the only time they attempted to get that fact before the court. If we go to the next slide, as soon as, and this is an answer to a question, I apologize for not having the actual question, but it again states the issue about, no, I'm sorry, I'd actually direct the court to line 21. What did she say Ms. Gardner relayed to her? And this is to the PR firm, that their tenant had been arrested and that the tenant owned the truck that the police were looking for. Again, this is this fact. And it was brought up multiple times by Ms. Stifler to try and convince you that there's no way Shanna Gardner would have known or should have known that Henry Tenon's truck was used in the murder. But we know, but later on during cross-examination, I was able to clarify that. But again, here's another transcript on the next slide, please, where she basically states, and I'll start on line 14, can you describe for the court what your investigation uncovered as to Mr. Thomas's knowledge regarding the charges? And then answer, just that they weren't sure what the charges were, but it seemed unrelated to the truck or anything to do with Jared. Question, and again, I like the way she keeps using the word and again, and this is Ms. Stifler telling you again and again and again that at the time these messages are being sent, nobody other than the people who hired Henry Tenon would know of his existence as to a link to the murder of Jared Brightigan. Correct. Other than the Jacksonville police. Correct. I don't know how that's done. And it's multiple attempts to try and convince this court of a false fact. And normally I wouldn't say anything. I would put this one on Detective Johns, but this is a question, a leading question that states all of these facts as if they're true and they know them to be true. But in fact, they are false and they know them to be false. The next issue if we go to the next slide, this is one of their slides. And this is a slide that they used to convince the court that this is the timeline of events of the flurry of calls about Tenon's unrelated charges. Again, to try and show the court that she's scrambling because she knows, and she's not supposed to know, that Tenon's truck was used in the murder and it's going to come back to her. And these times, I would submit to the court, are times that are taken from the timeline of this case and have been used, if we go to the next slide, in their probable cause affidavit in the support for application authorizing the interception of a recording device. Basically, one of their phone taps, they use this timeline specifically and these dates and times to lay out what occurred on that day. But as you can see, and what I brought out during cross-examination of Detective Johns, that Mr. Ordway, Henry Tenon's roommate, was told by the detectives specifically that Henry Tenon's truck was used in the murder. And I made a big deal out of it because, frankly, I think it's incredibly odd, and I have never seen in my career a detective giving sensitive information that hadn't been made public on a murder case to essentially a witness that could be, and by Detective John's own admission, could be involved himself. And he later, after not recalling, first he lied and said he didn't know anything about the conversation with Mr. Ordway, telling him he doesn't know what Mr. Ordway was told. And then upon being confronted, and I showed him the actual police report by his partner, Mr. Lamont, he then changed his story again, that he was told that in an attempt to get him to cooperate with them, to be a cooperator. And all the while, Your Honor, misleading you into the fact that there's no way Shanna Gardner or Mario Fernandez would have known that Henry Tenon's truck was used in the murder. It was a flat out attempt multiple times, as you can see through these transcripts, an attempt to mislead you, to take you down a path to think that this woman is absolutely guilty with proof evident, presumption great, when they knew that fact to be false. There was a conversation, and clearly here you see conversations between Mr. Ordway and Mario Fernandez, and then subsequent to that, those conversations, that's when these flurry of calls occur. Now, you take Ms. Jensen's testimony now, and you look at, and then we have the testimony of Detective Johns with this incredible meeting that occurred in July, where finally they had, and I don't know if the court understood this through the timeline of things, but she testified at the grand jury, but they didn't have her phone at the time. So after the grand jury, they then had her phone, and they extracted her text messages, and that's why they called her in July and had this meeting, and they put her in this room, this intimidation room, for lack of a better phrase, to sit there and sweat it out. And then we have two very experienced prosecutors, making themselves witnesses in this case because they chose not to record it. They chose not to write a report about it. Well, they can't write reports, but they chose not to have a police officer.
So again, wow, what a good point. Again, they made themselves witnesses. I know I've had a lot of thoughts. I don't want to interrupt him because it's so compelling and so linear. But since I paused for that, a couple things. So one thing that was noteworthy was how he mentioned that they relied upon the bit about the blue truck in order to get the permission to wiretap. Okay. So what I was thinking about that is going forward, when it gets to motions to suppress, you better believe they're going to make motions to suppress the wiretapping because it was made on, and we could even see a Franks hearing, which again, this is just another crazy overlap between this and Brian Koberger and then also Delphi, where with that Franks, right? If a search warrant, or a subpoena, if they have presented information to the court that was knowingly or intentionally false or made with a reckless disregard for the truth, such as the blue truck thing that we just heard about, right? Because he knew that had been leaked. Then that evidence you know, you can have a Frank's hearing to show, it would be the burden be on the defense to show that that was done, right? That the information relied upon to obtain said search warrant was knowingly and or intentionally false, or made with a reckless disregard for the truth. You can have a hearing it's an evidentiary hearing to show that, and then whatever was done as a result or obtained as a result of those warrants would be suppressed. Okay. So I'm already imagining that will be in our future. But also I wanted to note, it was interesting because there was talk from Kimmy. She said that when they met with her right before the Arthur hearing, so very recently, that they had mentioned something about there was going to be a plea deal, but that it might not happen, blah, blah. Now, I don't know if that's true or not, but what I was going to say is it is interesting. That's the first that I've heard of any talk of a plea deal as it pertains to Shanna. And it's really interesting that if you're offered think about it, right? If you're offered a plea deal and it's a death penalty case and they're willing to offer you something else, right? Probably life with the possibility, I don't know, anything else, right? Really, literally anything would be better than that. And you don't take it. What does that say, right? It's interesting. So there's that. And then I think I might have had some other thoughts, but anyway, I'll keep playing it and I'll pop back in if there's something else, but I don't want to interrupt him for too long because it's so compelling to listen to. And he's making so many points. I mean, a lot of information came out today. So
present. 3 members of the state attorney's office alone for, as you heard Ms. Jensen describe, confronting her with text messages, asking her statements about critical facts in this case. And she is giving them information that a lot of these things were jokes. That's the way we talk. That's a catchphrase, giving all of this exculpatory information that could help Ms. Gardner's cause to get a bond at this Arthur hearing, that could help me cross-examine this witness a lot more. And we were denied that as well at that very critical stage of these proceedings. You have one situation, okay. And we dealt with that situation where I think that when we had the disqualification issue of the state's attorney's office, albeit a completely different matter. And then we have Detective Johns, not just lying once, but time and time again.
I see where he's going. So they had the whole issue with the attorney-client privilege law. It's like, we dealt with that matter, but it's like, I can see where he's going with this. Like, this is I can see where there would be grounds where he might make a similar motion based upon any number of other issues that are completely separate but equal to the attorney-client privilege. Because now you've got them, like he pointed out, being made themselves witnesses in a different way than they were before already, right? Like ASA Stifler especially, but both of the prosecutors now, and then also soliciting false testimony from law enforcement. This is a mess.
On major critical facts and withholding information, misleading information, and flat out false information. This has no place in a court of law. This detective knows better, and these questions are completely inappropriate. It was riddled throughout the entire Arthur hearing. One misleading fact after another, after another, after another. And as you heard Ms. Jensen describe, all of these explanations occurred without anyone documenting anything now. Now, I am stuck with a situation where do we now have to list Mr. Mizrahi and Ms. Stifler as witnesses? Because Ms. Jensen clearly has a different take of what she told them than they do. And perhaps the summary might be enough for us, perhaps not. But the fact of the matter remains is we've got a big, big problem here. If they intend on using these text messages, I want to know what this critical witness said specifically to law enforcement, but I have absolutely no way of doing that unless I call one of these prosecutors to the stand, for which we never want to do. Then comes, I would say I saved the biggest flat out lie for last. And I go back to the court's order where the court simply followed the money. It's where they started with their case, and they showed you slides. If we can bring up, the court may recall this $5,000 transaction on March 15th from Shanna Gardner Irrevocable Trust. This incredibly damning piece of evidence was presented, highlighted here in a red box. And then the next slide, we go to the next slide. We then show the transfer on April 26 from Shanna Gardner Irrevocable Trust. So you got one in March, one in April. And then they showed you other bank statements. We can go to the actual Henry Tenon's standard checking statement. The prosecutor showed the court checks here in March where Mr. Tenon made these deposits from, of course, Mr. Fernandez's account, which ultimately, as the court said, follow the money, and as the prosecutors told you to follow the money, Your Honor. And then we had the actual checks. These are, again, I'm using the state's PowerPoint slides to show you the actual transactions where they tied it all together nice and neat in a bow for you. If we can go to the next slide. And I'm showing these for just as demonstrative so that the court can recall this portion of the state's presentation. So we have all of these statements, sign, seal, deliver. As ridiculous as the assertion was that this man committed a murder with no money up front and $5,000 later on of the $150 that he was promised. Okay, it still looks very bad for us. It still looks outrageous, or as the court used, incredible. And this is the court's order where the court utilized the information that the state
really
gave
excited to see what he's going to say here.
to make its actual just decision.
Mm-hmm.
Not only did the defendant conspire to find a hitman, that's questionable because, of course, we now know the text messages were that of a joke, and I don't know if the court recalls Detective Johns falsely testifying about a tattoo artist that when Shanna Gardner had asked him about knowing someone, that he stated he didn't think it had anything to do with murder, but yet Detective Johns, in his inability to be honest, said that it was for, in fact, to actually find someone for murder. But she also funded the cost. The $5,000 sent to Tenon as the first payment for killing her ex-husband came from her trust account. Following the money, Fernandez transferred the money from the trust account to the LLC that they co-owned. Ultimately, Fernandez wrote a check from the LLC to pay Tenon for the murder. Defendant argues Fernandez had complete control of their finances and she was unaware of his dealings with Tenon. The defense argument is incredible considering the evidence. Now, I want to go back to the very first slide so we can follow the money once again. Can we go back to the first slide? These prosecutors took these bank statements, and as we all know, they're monthly bank statements. They put them on a PowerPoint, but I would direct the court's attention to look at the statement period for this date, for this specific transaction, which, as you can see, is March 1st of 2021. The murder did not occur until a year later.
No.
To put this before the court, to insinuate, and if you
Oh my God.
look at the very next
No
slide,
way.
then we go to April 26th.
Oh boy.
April 1st, 2021 to April 30th, 2021. That is the statement period for these messages. And then if we go to the next slides down, when we get to Henry Tenon's checking account, we're talking about a checking account on March of 2022, not 2021. They want you to follow the money, Your Honor, but they want you to follow their path to the money, which clearly is false and absolutely misleading and has no place before this court. You take this and each and every one of Detective John's lies,
Here's the thing.
these issues one after another, after another.
They must have not realized that at the time. They must have realized that after the fact. But if the prosecution misrepresented in that evidence to the court, that's a problem. The court, like, what's going to happen? This is insane.
After another.
Wow.
It's shocking that we have so much
Yeah.
to criticize and so much to point out. But if you even just take this issue here, everybody knows you get your monthly statements. They had to look at March of 2022 and April of 2022 because that's when the murder occurred. And that's when Henry Tenon's telling him he got this money. And it's true, he did get money, but it didn't come from the Shanna Gardner Trust. So what I find even more shocking is you got to go back. Okay, well, we don't have any money coming from Shanna Gardner. And that's how they tie Shanna Gardner to all of this, through the money. And if you look at back to the April 1 of 2021, just to be clear that it didn't come from the Shanna Gardner Trust. If you look right below their red box that they want you to focus on only, check 1052, he empties out the entire account. It's at 18,000. He writes a check for 16,000. There's no longer any money. There's just 1,900 basically left. So you know now that they're lying to you, misleading you, putting forward false.
So what did I say earlier when it came to the judge and what she cited for her reasons for denying bond? You know, we had the grand jury testimony from Kimmy, we had the text messages from Kimmy, right? And all of that. And remember what I said? I said, well, what have you got left? I've said you've got the fact that she said the financial gain, following the finances. And I thought to myself that was kind of, you know, the one thing that maybe would be harder to dispute. But I spoke too soon. Wow.
I guess it's a real document, so I can't call it a false document. But this is shameful and nothing less. And again, it's the only thing, it's what specifically ties Shanna Gardner to these checks and to this money. And just like the truck, where they try to mislead you on that, and just like with the Susan Lee text messages, where they try to mislead you on that, and well, they don't only mislead you, they misled us. We had no ability to defend her on a lot of these issues.
Right.
And the court knows, look, I think I could have caught it during the hearing, but I'm focused on my cross.
That's what I said. I was like, he didn't catch it. But after I said that, I thought to myself, you know what? They probably had no reason to doubt that the dates were wrong, because that would be unfathomable, right? Like that would be unfathomable. And same thing with the court. The court didn't catch it either. It's almost like you would never even think it would be possible. So you wouldn't even double check that, because how you would never imagine that they're going to present those checks where the year, it's the wrong year, and where they didn't even show you the number at the bottom and stuff. Like, it's crazy.
I'm focused on what's going on. There's a million things. As a trial lawyer, the court knows there's millions of things, and to go through a detailed bank statement and to be able to pull that out is quite difficult.
Don't blame yourself. It's okay.
And then there's this fact. Your Honor, I looked for the actual April and March.
Oh dear.
Bank records for this account in the discovery, upon discovering this, and we do not have them.
Okay.
I have asked our co-defendants, Ms. Day, our co-defendants counsel, if they have them, and I'm sure as officers of the court, they can stand up and say they don't have them either.
For 2022?
Correct. So now you have to ask yourself, why are those not? Why are the months of the murder, or the months following, the 2 months following the murder, for which they based this whole...
So what the state did was they hoped that no one would notice it. They submitted the correct months of the previous year and didn't turn over the discovery for the actual months of the year in question, and tried to submit the wrong year as if it was the correct year and hope no one would notice. That's what that looks like. No way. No way.
Indictment on it.
No
It's
way.
part of, it's all over the discovery of how these checks were written,
Yeah.
how the money came from
the entire thing.
Mario Fernandez and Shanna Gardner,
boy.
and all of these facts. But yet, the bank statements disappeared, or we don't have them. That's all I can say. And we come before you to try and get Ms. Gardner, have at least her ability to be with her children. And this gets presented before the court. This gets sent to the point where it was detailed in quite significant fashion in your order, for which you considered to deny Miss Gardner's motion. I think, I'm a little stuck where there's just so much.
Here's the thing
here of false and misleading information.
Here's the thing. So if those checks and everything that tie all these people to the case, including Henry Tenon, are from the wrong year, I don't know how they have a case. I mean, they had his confession, right? But this is where this for me is getting into the territory of, was there like a false or coerced confession? Because the thing is that if he confessed and said, "Yup, they paid me," and he gave the story that they were putting forth, but the evidence is that that was a different year, what that should mean is that that's, if you're doing your job correctly, then you should take a look and say this was maybe a false or coerced confession, because in essence, he told them it was at that time, right? A month before the murder and a month after or whatever. That's what he told them. And then the financial information that they have shown is it's the previous year. There's a problem. Like, in other words, if that's a false confession, maybe, I mean, I can't even believe that this could be the case, but like maybe these three people are factually innocent, really, because it really all hinged on that confession and then these financial documents that could tie any of these three people to each other or to this happening. But if that's all the wrong year, this is completely different. This is the question, right? Because I don't really know how it's not been dismissed. Like, I'm shocked. I'm shocked because their entire thing hinged on those checks. That was it. And where's the relevancy from that? It came from his confession. His confession saying that they paid, remember, it was, so they were joking about it because who does a murder up front without any money, right? But it was supposed to be a month after. Well, it was a month after because the murder was in February, right? And this was a month after because it was March, but it was the previous year. Oh boy. Oh boy.
Information presented that we had no choice to bring it to your attention. Because
maybe,
I think if you had known the truth, the results may have been different. Your consideration would certainly have been different. And that this court deserves the truth. We all do. And this process is supposed to be a search for the truth.
I mean, this has gone from like, iffy evidence, blah, blah, to like, wait a second. Is there anything in, like, that's all, like everything they have then is questionable now, right? Because this calls into question even the confession, because the financial information they have doesn't match the confession. So this is oh my God.
Anything but.
And it's like, well, then who? I mean, see, now it's like, well, the people should be asking themselves who really did it, right? Because if that's the case, and that needs to be done, that needs to be figured out. The thing is you have to think about with false confessions, right? Henry Tenon had a previous record. And when that's the case, you can see how it'd be much more likely to make a false confession. The other thing, I've asked myself time and time again on these live streams, how the fuck did he get the deal he got, right? Because normally, if you are the hitman, like, again, take any of these other cases, right? If you're the hitman, you really are usually ending up with charges that are the same as the principal people, right? First degree. And that's why I was like, well, how come they didn't charge him with first degree? They charged him initially with second degree, but then the deal that he took, it's putting him at like, like a manslaughter at best, right? It's like 15 years, but he's gonna have time served. I mean, it's crazy. And I thought, why did they give him such a good deal? Because, that doesn't make any sense even for other cases in Florida where there's like almost similar, like, again, you can compare it to the Adelsons, right? Because super similar in the scheme. And anyway, but it does make you wonder, right? I don't know. It does make you wonder if, you could see how with someone who's got a prior record, right, that they could get you to maybe falsely confess, especially when it's like, look, this looks really bad against you. And because of your past record, you would end up doing a lot of years. But look, we're going to offer you this deal, and it's only going to be 15 years if you testify. You can, they would use that against him, right, to get a confession. I mean, that's how it works with these things, that if you've got a prior record and you know, the person is like, yeah, and then they add that to it. It's like, yeah, because of that, you're going to be facing this and this and the other thing. And that's like, well, look, we'll cut you a deal. I mean, you add it all up, you can see where the 15 years comes in, because to me, that seemed fishy from the beginning when I read that. And we covered that, I think probably the first live stream, we covered that. And I was like, that doesn't make any type of sense. It's too good of a deal if they believe any of this. It's too good of a deal. It's like they way undercharged him, and then they way overcharged everybody else. And that's assuming any of this is true, which now it's looking like this entire thing, I don't even know, man. Yeah, I mean, I agree. It is starting to paint a very ugly picture. Because again, if any of it were legitimate with Henry, right, that deal doesn't make any sense. I've never seen anything like that, you know. It speaks to a couple things. It speaks to the type of deal you would make if you're law enforcement or you're the prosecution, and you maybe know that you're eliciting a false confession in a way. But also, if you're the person who's taking the deal, and again, you have a history of being convicted, and that they're telling you, look, just this is going to, you would be more likely to believe them that it's open and shut against you, even if you know you didn't do it, right? And that they're like, this is your best bet. Take this 15 years. You're never going to get a better deal. If you're convicted, you could get life, whatever it is that they say. And you would believe that, especially because of your prior convictions, you would be more likely to take the deal if it's 15 years. Like, let's say you know you didn't do it. Let's say you know you didn't. I mean, this is the difficulty with plea deals. This is part of the controversy, right? Because if you know you didn't do something, but they're like, look, it doesn't matter. This looks really bad against you. If you get convicted, it could be life or it could be 50 years or whatever. But look, if you take this deal, it's 15 years. If you know you didn't do it, but you're like, this is the gamble. If you believe what they're saying, you're like, that's my gamble, right? This is how you end up with these false confessions, because they don't want to take that gamble. They're like, okay, if they're telling me it's definitely going to be life or it's definitely going to be 50 years versus a guaranteed 15, why would I gamble, right? This happens. And then you take the 15. But here's the thing. If they make that same offer to you with the gamble, right? And they're like, yeah, if you get convicted, it's going to be minimum 50 years. But look, if you take this deal, we'll offer you 40. Then you might take the gamble. You see what I mean? That's where the years matter. Because if they offer you a number like that, 15 years, you might say, you know what, that's not worth the gamble. But if they were to offer you something that's even remotely close to what you could be given if you take it to trial, and if they charge you appropriately, which in this case, they didn't, right, to begin with, you see the difference there, right? It's like, what's 40 years versus 50 years, right? But 15 years, and especially when you have a record, it's a big difference. And you're like, yeah, I'm not going to take that gamble. The fact that the checks that he described happening at the year of the murder happened the year prior is, I can't even wrap my head around it at all. I don't know what how the state's going to handle this, but we'll see.
One incident, I get it. And I know, and I read the court's order on the motion for disqualification. I know the court was not a fan of what occurred, but we're all human. We all make mistakes.
Yeah.
I get it.
This is what I was saying, right? This is what I was saying, is like that this is a whole completely different thing. Like, it was fair that she said, okay, I'll give them a second chance, right? That's as it pertains to the attorney-client privilege, but this is completely different.
A mistake. This is not negligence. This is not bad lawyering. This is a pattern, a clear and distinct pattern of trying to skirt justice and the truth.
No kidding.
And it is deeply embedded in the black letter law of this state that this is a death penalty case, and we all know that death is different.
Yeah.
I think, given all of these things put together, you have reckless conduct by significant members of, by significant witnesses. And I have no idea how something like this would occur. And
yeah, the check. That's crazy. That is, even he's getting speechless. I'm speechless. I mean, I'm not speechless. I don't even know what to say. I feel like I'm speechless, but like, that thing with the checks is mind-boggling. That they presented that and hoped no one would notice it was the wrong year. And you know what? It worked at first. I wonder who noticed it. It's very likely it could have been even somebody watching this hearing that contacted them and said, hey, did you realize it? I don't know. But everyone missed it. The judge missed it. We missed it. He missed it. We did exactly what the state hoped would happen, which is you just assume it's the right year, because how could you possibly submit the wrong year and offer it as if it's the correct year to match the testimony that you're giving based on the confession? You can't, it's not, I can't.
I can be frank with the court and tell you, upon finding out this information, one of the things that we considered would be knowing that maybe this won't make a difference, and maybe it's best to sit on this card and utilize this during the trial. But it's not, upon discussion and consideration, it's not our job to subvert the truth. It's our job to work towards it. And I don't think we could have sat by and allowed you to think one thing and to be misled under these circumstances and not say anything.
Yeah.
A lot of these issues we could have put off, but it's the false statements, the withholding of critical information.
I find it shocking that he thinks they're still going to trial, because at this point, I don't see really how, I don't really know. I mean, in my mind, it's like, time served, you're free to go. Like, I don't know.
Defense information that's favorable to Miss Gardner, it's like a cancer that is riddled throughout the evidence in this case, where I don't know if the court can accurately or effectively trust any of it.
Yeah.
And I hope the court knows I'm a little bit more articulate than this, but I'm using my words very carefully here. And because I find no pleasure in this whatsoever. I want this process to be a just and fair process. We both want to put on our cases. But I've taken an oath, and I cannot stand by and allow this to happen without calling it out.
Yeah.
And it's just a very difficult thing for me to do, but one that I think.
I wonder.
So obviously.
Okay. Right before. I wonder when he's gonna start thinking. He may not say it out loud. We may not know about it. This could be going on behind the scenes. But I wonder when he's gonna think what I'm thinking, which is, wait a second, what's in that confession? Because is this a false confession? Because if it's a false confession, everybody should be going home, right? Including Henry.
This doesn't get brought before the court very often. In fact.
No kidding, dude. Oh my God.
It's been urged that I not even hear it. Pre-trial Richardson hearings are rare. They can occur. What are you asking me to do?
Well,
wow.
I think the court has various remedies.
Shoot for the moon. Shoot for the moon. Do it. Wow.
And we outline them in our motion.
That was before you added the check thing in, though.
What is the authority for dismissal, though?
Oh my God. She said, she suggested it. She suggested it. That was, dude, she's at where I'm at. How does this not get dismissed then? What is the authority for dismissal? She's at where I'm at. What he just showed with this check is the case goes bye-bye. Like, this is, dude, can we hear that again? Oh my God. Oh my God. Oh my God. Oh my God. Oh my God.
Can occur. What are you asking me to do?
Well, I think the court has various remedies, and we outline them.
This is just like, this reminds me of in Baldwin, when you heard something similar from the court in Baldwin, Judge Marlowe, where she said something similar like that, like, what are you asking me to do? But then she went ahead and referenced what she thought was the right thing, which is a dismissal. This is, listen, She says, what are you asking me to do?
Oh, Richardson hearings are rare. They can occur.
So she's saying a Richardson hearing, so having another hearing, but then she's like,
what are you asking me to do?
What are you asking me to do?
Well, I think the court has various remedies, and we outline them in our motion.
In the motion, the remedies, I don't even think dismissal was mentioned in there, which is why next part is especially fascinating.
What is the authority for dismissal, though?
It's like she's jumping past the remedies he suggested. What is the authority for dismissal? Wow.
So let's say I take the position you want me to. I don't know of any authority that gives me that ability to sanction that way. When things are happening pre-trial, the law that I've read is it's
okay.
Exclusion most of the time also is cautioned
Okay.
by the.
So I think what's happening here is that, like, okay. And remember what Mr. Bias said. He said, I could have held this card and waited to bring it up until trial. But I don't feel like it's fair for the court to be lied to. Okay. Okay. So as we know, Richardson hearing, that's why she mentioned that. So in other words, usually this would come up at trial. And the thing is like, if he, okay, I can see what this is about. So if he brought this up at trial, okay. If he'd brought this up at trial, I think this was a gamble on his part, and he probably consulted with Shanna. If he'd brought this up at trial, and in fact, I mean, I don't think there's any way around it. Like the dates are what the dates are. Dismissal. Now, again, it could have been like, well, I don't know if it would have been with prejudice or without prejudice. Probably with prejudice would have been dismissal. In other words, what they're saying is the authority, there's not as much that pertains to pretrial, because normally this would happen at trial, and that would be different. I think the reason he brought it up now, like he said, I could have waited, and he said he didn't think it was fair for the court to be lied to. But I also have to wonder this. I also have to wonder if the thing about her son being terminally ill, if he talked to Shanna about this and she said to him, this is just my thoughts, that maybe she said it is more important to use this now in the hopes that I can get out on bond so I can be with my son, maybe. Because he might have told her flat out, if we wait until trial, dismissal. And this is your call, right? And it's kind of a gamble. Do you want to use it now or do you want to use it at trial? Maybe. We'll see what happens.
The court, and that's a remedy asked for in the motion. So in light of what you've explained to me today, if I were to see it your way, what do you want me to do?
To the moon. But yeah, they have to have the authority. So that is one thing.
I think, and we're going to pull the exact issue or pull the exact source on this, but I believe that either the rules of procedure or case law give the court the authority and the ability to fashion multiple types of remedies in a case up to and including dismissal.
Okay.
It's a rare remedy. It's rarely granted. I recognize that. But we're really talking about some rare conduct here.
Yeah, I agree. It is rare. It is
And
rare. So I think what he's going to be going towards here is a lot of times it'll be like in the court's discretion. And I agree. This is rare, and I've never seen anything like this. And this would be the argument here is to make it to the court is this is your time. This is the time to use that authority because this warrants it.
And I think for us, obviously, there's a hierarchy of remedies that we would seek. And we certainly do not want to take that off the table in terms of what the court should do. You know, I stand in the shoes of a criminal defense lawyer proudly. And my first reaction would be, yes, this case should be thrown out. It should be tossed because at this point, it has been so infected, even from before when the case started, when you've got lawyers coming in here, smart lawyers who had the forethought to think, hey, there's some devices with attorney-client privilege that you shouldn't be viewing. And they actually were granted, they went through this whole extreme thing, and I'm not gonna restate all of what occurred previously, but all of those things occurred to make sure fair play and justice occurs. And that occurred. Okay, we had the ruling on that, but the conduct continues, and you've got a detective serving subpoenas in Utah
Insane. It's insane.
where they have no authority to do that. It's
And
essentially
the thing is it doesn't match the confession. Like, I am just so dumbfounded by this. Because what are they going to do? Are they going to try to call Henry Tenon and get him to change his testimony and say it was the previous year? I don't understand. They're kind of stuck with it one way or the other, either like not using him or like, but then they don't have a case. I don't even know.
a crime. It's a misdemeanor to present something as an official subpoena when in fact it is not.
So basically, the lead detective has committed a misdemeanor crime.
So how do we have a trial with the lead detective continuing through this course of conduct and all of these things
The prosecutors having made themselves witnesses now on at least 2 occasions.
Secret meetings occurring without being recording with arguably the most important witness of the case, describing the only piece of evidence in the case that implicates Ms. Gardner. Again,
Yeah, this is crazy.
I understand I understood the court's conclusion after being misled with all of these different things, but she's nowhere near the scene of the murder. She is married to an individual. Yes, but we didn't go through text messages of Shanna Gardner telling Mario how much she wants him killed or anything, even way back when they first met. Since if these text messages are not stale, there should be things in there that specifically are related to Mario Fernandez and Shanna Gardner, but there's no such thing. You didn't hear about any of that or any of these other individuals. So it's a mess. For lack of a better phrase, it's an absolute mess. Now, in that hierarchy, yes, we would ask for exclusion of these text messages. You've got to do something.
I think that part of the challenge that he has is that there's so many issues. It's hard to even answer the question of what remedy, because normally you would have one issue and then you'd be able to narrow down the remedies, but there's so many different issues. It's hard to even know where to begin with the remedies. And that's where dismissal seems like the only option here.
To stop this type of conduct. Okay, and I'm just a blanket. I'm not calling anybody's names out, but governmental conduct. The only way you can prevent that from happening again is through sanctions to prevent them. And the courts have determined exclusion to be one of those, to be an actual remedy for that cause. And the cause is our government should not be doing this to any citizen accused. Our government should not have.
Even exclusion. Think about that, right? Even if you just ask for dismissal, if it's exclusion of this evidence, and that by that meaning the checks, the bank statements, even if you just exclude that, you have no case. They wouldn't have a case. Like, in other words, you wouldn't. Okay, if he doesn't ask the judge to dismiss it, which he probably will, but even if she doesn't, if it's exclusion of this evidence, and even if you just say it's just this check, even if you just take that one piece out, right, the bank statements, they have no case and they would have to choose they can drop the charges, right? So in other words, you wouldn't have to, if it's like asking too much of the judge to ask her to dismiss it, you can have her dismiss this evidence and then the state has no case and they have to drop it, right?
Detectives on the stand lying to a judge and going off in other states and serving subpoenas that aren't valid and committing misdemeanor crimes over there. And then just one piece of evidence after another that is just a flagrant attempt to mislead the court.
So if I take what's at the back of the motion that was filed on behalf of Ms. Gardner, it asks for the special jury instruction to draw an inference related to Detective Johns. And I'm familiar with that based on, generally that comes when there's a specific destruction of evidence. It's a negative inference instruction. So the defense is requesting that potentially, but that's later on down the line. If you were to ask for that. Exclusion of text messages, exclusion of any statements made by Ms. Gardner.
I think the court has to.
And I'm assuming D means reconsider the information at the bond hearing.
Yes, because this misconduct was done in the effort to keep her incarcerated. I think it's only fair that she be released because of it. Otherwise, you know, when it has to be a remedy strong enough to prevent them and to discourage them from doing it again. That
Then
didn't
again,
occur.
you asked for disqualification.
Correct. When we did the disqualification, it's interesting because when that argument was going on, I had the ability to observe most of it, if not all, and I don't think they were worried one bit that there was going to be that they were going to be disqualified.
That's a good point. I agree with him. Because they didn't even cite any case. They didn't bother to even use any case law. That's a great example. I agree. And so his point here is they feel like they're invincible. That's the point. And we've seen this with other offices. We've seen this with people like in Karen Reed and with Delphi, where these offices feel like they're invincible and no matter what, it's going to be. And I agree with him. And you know what? We saw the same thing like in Delphi, where I think Delphi and Karen Reed, where like the state would never provide any case. They didn't bother to use any case law. And it's like, it's the same thing here where they just, his point is they're just going to keep doing this, right?
Mr. Mizrahi came up there. He didn't have any notes, any case law.
That's a squirrely crystal ball moment, but I'm not going to play it because I don't want to disrupt you.
It was quite clear that they didn't feel that this was much of, enough to warrant anything and that nothing was going to happen.
For it, yeah.
This is much more serious.
Yes, I agree.
I can't.
So he's saying like they made that motion to disqualify on all that other stuff with the attorney-client privilege, but like that's not even in the same category as this. It's like in my mind, and I feel like this is probably what he's thinking, and this is certainly what I'm thinking. Dismissal isn't even good enough. Like dismissal of the case and they all need to be fired is like, you know what I mean? Or like disbarred, like that type of thing.
I'm having a hard time arguing because
I get
how
it.
could they sit here and present this evidence to you and attempt to mislead you and take you down this path?
Mr. Baez, I'm with you 100%. I get it.
Where
this is crazy.
It's shocking to say the least. And it has to be a shocking response from the court to prevent them from doing it again.
Yeah. Disbarring them would also help that.
If Susan Lee would not have been watching, we would not have been able to bring
and this is what I said. This is what I said. That's what I said.
This to your attention.
And that is such a shame, right? God.
Jensen was not watching. We wouldn't have found out until much later on. And who knows how her memory would have been affected as to what occurred on that specific situation. Wow. But they all, and even you got a woman in Utah who's watching too. Yep. And everybody's outraged by Detective Johnson's testimony.
And they're all reaching out to the defense.
Mischaracterization of the facts is reckless disregard for the truth.
There it is, reckless disregard for the truth. So there you go. Now you're back at that standard for evidence being suppressed.
They're coming forward. But for these cameras, a citizen accused.
This is what I said. This is what I said a long time ago. But for these cameras, here it is, guys.
Would be helpless to respond, and we would not have the ability to respond at least effectively. Well, it certainly wasn't effective enough because our motion got denied. So I think
I
think I think it's quite obvious this is a serious matter. I
think it's clear that he and I think a lot alike. Mr. Baez, I love you. You're
choose serious conduct, and again, death is different. We have those marching orders with death penalty cases that while we follow the same rules, the consequences are so much greater. So we have to be that much more. I
mean, I understand why he's saying this, but with what we've seen today, I don't even care what type of case it was and what the, death penalty or not, or whatever. I understand why he's saying this, but like, this is so egregious that it just doesn't even, you don't even need to apply that standard. I mean, this is insanity. Like, this just needs to be, I don't even know.
In line. We have to follow the law that much closer. And extra attention needs to be paid and extra diligence needs to be done, especially from ministers of justice. I think if I'm not mistaken, the U.S. Supreme Court in Reed was quite clear about our roles in the system. My role is that of her advocate. To be her voice.
Fuck yeah.
Their role is to seek the truth, to be ministers of justice, and to not put forward this type of evidence, to not support this type of conduct, and to not be a part of it in any way, shape, or form.
Oh my God.
That's why they're granted this incredible, awesome power of discretion.
Mm-hmm. Yep.
They don't give that to just anyone. So if they have the discretion to not only charge someone with murder, but to actually ask for the ultimate penalty of death.
Yep.
There comes with that comes with a lot of responsibility.
This is,
and I think
this is important. This
I
is
think
good stuff.
that responsibility has fallen. They have fallen very short
Yeah.
in terms of their responsibility in that matter.
I think he's holding back tears, to be honest with you guys. I think he's holding back tears, and I don't blame him, because this is really depressing.
And
it's bigger than Shanna. This is not.
We think, as we laid out in our motion, we think that this obviously was a situation to prevent Ms. Gardner from being set free during pretrial. At the very minimum,
Yeah.
she should be released.
Right.
At the very minimum. But I think that this conduct goes far beyond that.
Yeah.
And I hope
It's changed. As they've learned more, it's changed. It's like, we need to, for me, it's like dismissal and disbarment, right? But like, yeah, he's like, we started out trying to get her released from pretrial detention, but like, it's gone beyond that.
the court considers that.
Wow. Powerful.
That's your Honor's place in our system to make that decision. You call the balls and strikes, and you also make the tough calls. But I don't want to be a part of any of this.
Yeah.
And I hope, and I ask that the court not either. I know the court doesn't want to either.
Yeah.
But something has to be done about this. And again, I apologize for my lack of fluidity here in terms of my arguments, but I don't make them lightly, and I don't want to say specific names or things like that. And I really have tried my best to do it to the point of the bare minimum while still fulfilling my oath to this woman.
Yeah.
Unless the court has any other questions, I rest on those arguments.
Wow.
I want to be clear, while you're asking the court to do something, I can't do it of my own volition. It has to be a request by the defense. So I want to make sure that So
what she's saying is she can't just choose to dismiss the case or anything else. It has to be, that's why she said, what do you want me to do here? So he has to ask specifically for the remedy, for the sanction, so that she can grant it or deny it or whatever.
Your motion is what you're asking me to evaluate as far as potential. If I saw everything your way, that is a potential.
So I think the other distinction here is that in the motion, which we read right before this, right, there's sort of specific things he's asking for. I don't think dismissal is even a part of that. And I think what she's trying to say is what's in your motion, what you're still asking for, because it seems like this whole thing with the check was discovered after that. And so if there's something else you're asking for, you need to say it now, basically.
Remedies that you would seek, and I would then decide what the appropriateness of that is based on the information that you given me in this hearing.
Yes, I would answer in the affirmative that yes, we would seek dismissal. In the alternative,
okay, so dismissal wasn't listed as a remedy. Okay.
Would seek exclusion. In the alternative, we would seek exclusion and her release, and at the very bare minimum, her release, a reconsideration and her release. I have hesitated saying this before, and I know I know the court has seen that hesitation before, but I haven't been shy about it either. And I think that I don't want to be dealing with the Hail Mary of a jailhouse snitch, because this type of conduct occurs. She gets stuck in jail, and now we have to deal with someone making things up and just turning this even into a bigger circus than it already is. I don't want to go there, and I have had deep concerns. And look, I also have enough experience to know what happens next.
Yeah.
Especially when stuff like this is happening. So we really haven't even started this case, and look at all of the mud that we're trying to get through.
True.
And
so true.
It's an incredible mess.
Yeah,
and
it is.
I can't.
Yeah, I agree.
I can't believe this evidence was presented to you. I can't believe
this is. Yeah.
That that Detective Johns testified as such. He should be ashamed of himself.
For real.
And I really think that a strong response from the court is warranted in terms of the relief that the court.
Wow.
We hope justly decides and executes in this matter.
Wow.
Thank you.
Yeah. Well said.
Chair, my response will be brief. I may have to share my time with Stifler about some particular issues, since many of the things that we heard here today were brought up to our attention for the first time. My only direct response to Mr. Baez is that I have been doing this job that is very dear to me for over 25 years. And I find it very difficult to be lectured.
Well, here's the thing. This is to Mr. Baez's point. You've been doing it for over 25 years. that is probably why you feel like you can get away with stuff. But also, have you been getting away with stuff for that long? And what else now do we need to be looking into? Because, I mean, the fact that that's what he says and starts out with just goes to show you exactly why this is a problem. Because his response is, I've been doing this for 25 years. Does he not realize that you're making Mr. Baez's point? Like the fact, I don't have words.
About how to be a prosecutor and how to take the solemn responsibility that
So he's like, I'm offended, blah, blah, but not refuting anything yet.
the people of the state of Florida have entrusted to me.
Gross. This is gross.
And then to be lectured by a person that stands on the steps of the courthouse and gives press conference in violation of our professional rules of conduct. And then comes into this court and brings up issues that he's never raised before in paper motions, which is the way things are done, which is the way we're taught in law school. If you file a motion, you ask for a remedy, and then Mr. Baez makes up remedies as he's standing here in court about dismissals, which were never asked for in the paper pleading. Neither was anything.
So I was right. I was right. Okay. Okay. Well, that clarified. Well, if he's right, but I remember thinking they didn't ask for dismissal as I went through that. But remember when I got to that part, I didn't go through all the remedies because I was like, oh yeah, we know what the remedies are. And I didn't read all of it, but I noticed that I didn't see dismissal. So that's why I kept mentioning that. But damn it. So this is really going to matter here in terms of, is he asking for something that he didn't put in writing? Because that's why the judge, I remember she asked him to clarify. She was like, are you asking for what you asked for in your motion? Anyway, I'm sure they'll talk about it more.
Do with Ms. Luchetti mentioned in the paper pleading. Neither was anything mentioned about the defense's different interpretation of the bank records mentioned in any pleading.
And having said that, this is not a good, it does not help them, right? Because a lot of the stuff that came out after that pleading, right? Because that was in June. Now we're in August. So this is pointless. What he's saying is pointless. But not only that, what it's not doing is addressing any of the issues which point directly at him and his office and his detective. And instead, it's just like they didn't ask for this stuff in the pleading. It's irrelevant, really. So,
and that is the only other thing I would say about the banking records is obviously the state is obligated to disclose all evidence in the case. We have gone through great pains to discover the voluminous records in the case. We obviously discovered the records in the case during the course of the hearing. The fact that this is the first time that either Ms. Stifler or I have heard a word about not having these bank records, and then they put it up on a screen in court in front of cameras and say, we never got this. A phone call, an email would have sufficed.
Do you guys see what he's doing? He's twisting it around. Wow. The problem isn't just that you didn't turn over the correct months, and he knows it. The problem is that they sneak-a-doodled in the wrong year and tried to make it seem like it was the correct year. That's the problem.
Oh, boy. And we have provided those copies of the records, which we obviously believed were provided in the entire time, if they were not previously provided. With regard to the actual motion and what they're claiming, because obviously all they wanted to do here was to rail on the state and basically have another bond hearing. I want to put in what was previously introduced into evidence, which are the text messages.
Clear to me, he's ignoring the actual problems. This is disgusting. And this is exactly why Mr. Baez said what he said, because it's clear that this is someone who thinks he's just going to keep getting away with it and isn't even actually really concerned. Yeah. I hope Judge Kite is noticing what I'm noticing.
That obviously Ms. Lee and Ms. Jensen have a subjective feeling about what they were about. But of course, what was buried in there is the actual text messages. So just for the record, and you can easily refer to it. Kim Jensen said, quote, Shanna needs a guy, end quote. Susan Lee says, quote, what kind of guy, end quote. Ms. Jensen says, quote, the kind that perform permanent disappearing acts on certain people. Know any magician? End quote. Susan Lee says, quote, I'm a magician. No, that I do not. For stupid, end quote. Ms. Jensen says, I was thinking of Thomas, LOL. Ms. Lee says, he isn't a magician, but I'll ask if he knows any. Ms. Lee says, I'm sure he knows a few. So their characterization and subjective belief, which by the way, was 100% disclosed before this, the bond hearing. And if any claim is just false that it wasn't disclosed because they had the grand jury testimony. We have the emails that we have attached to our response that indicate that they knew about all of this. So this is, they argued it to Your Honor. So but the objective evidence is what it is. If a defendant comes into court and says, I shot somebody, he can come back later and say he's kidding, but the state doesn't have to disclose that, even though we did disclose it. It's also interesting about the whole concept of Susan Lee, that somehow we're trying to hide the ball when we provided the name Susan Lee to the defense in these text messages. These are all people that are friends of the defendant. The fact that we haven't spoken to her is not evidence of hiding the ball. They found out about her because we disclosed her name. It's part of the evidence in our case. They say that the detective lied.
This is crazy. This is crazy.
In some pattern of conduct, they're referring to his partner's reports to impeach him. I know Your Honor is so familiar. So we're talking about the text messages and the reports or things that were just.
I mean, Judge Kite was here. We were all here when he testified that he didn't speak to her, and that's false. So
disclosed that they have, and they're using it to impeach. Mr. Bias spent the last 30 minutes of the argument talking about a record that states what it states.
You know what he's doing here? You know what he's doing? You know what this is? I was like, what is this like? This is like a politician. What he's doing is he's doing that thing that you'll see politicians do, where he's completely ignoring the facts and the evidence and literally the actual legitimate argument that was made and everything that was made. He's literally ignoring it and just using gestures and loud voice and like da 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 to like try to make it seem like he's making a point. And that's what he's been doing every single time. That's what it is. I pointed it out at the other hearings. I'm like, wow, like his gestures are really distracting. It seems like it's just word salad. You know, I pointed out that he's not citing any case law and all this, but I didn't, it's just dawning on me now what it reminds me of. And it's like a politician when they're trying to feed you bullshit.
Funds from Ms. Gardner's account funded Mr. Fernandez's account. There's no hiding of anything. We didn't white out the dates of the transactions or anything like that. The concept that the state of Florida is not allowed to meet with a witness, and I'm glad Mr. Bias actually clarified it because now the court can see the whole purpose behind that. Ms. Jensen, on multiple occasions, sat down with the police and says she knows nothing about this case. No one has no suspects, no idea, no concept of what's happening. And then she's subpoenaed before the grand jury and under oath discloses for the first time that Shanna Gardner told her that the defendant, Mario, her husband, was going to, whatever the catchphrase is, I don't want to say it wrong, the catchphrase about the victim in this case, and that she told him not to. That was, of course, the first time any of that was discovered. And then lo and behold, when we get the search warrant of Ms. Jensen's phone, we discover all these other text messages that show that the conduct went way beyond all of that. Hence, a subsequent bring down to the state attorney's office to discuss it with her and the possibility that she is withholding evidence, which she was, because in that subsequent meeting, as she indicated under oath here today, there were multiple other statements that Ms. Gardner indicated to her about Mr. Mario Fernandez boasting about his ability to take care of whoever it was. I believe it was. So, I mean,
Whoa.
They listed Ms. Jensen as a witness. And according to the Florida Rules of Criminal Procedure, they listed her as a witness that they intended to call. That's the defendant's responsibility. They don't have to list anyone that has no. They listed Ms. Jensen as a witness since December 2nd of 2023. We just heard an hour of railing on us withholding evidence, and they had listed the witness since 2023, stating their intent to call that witness.
What? How is that?
That's the only incredible thing that we've heard here today.
Oh boy.
Obviously, people can have, in every other respect, I'll rely upon our response. People can have different interpretations. They can come into court and say this was all a joke. That's great. We are in the very beginning pre-trial stages of this case. We're doing our best to make sure that we speedily do discovery. This is not helping. We would like to get our depositions done and get Ms. Gardner in front of a jury of her peers so these wonderful arguments and these wonderful attorneys can make their arguments and stand up and argue with a jury about whether or not.
Sarcasm by calling them wonderful. What I'm hearing is this. We don't want to waste time on this, Your Honor. We want to go ahead and get to trial before they discover more things that we're lying about or more evidence. Like, you see what I mean? It's like, we just want to get her to trial. Let's just ignore all this. This doesn't matter. Let's just get her to trial. Yeah, before we've actually gone through and like addressed all of these issues, you mean?
Ms. Gardner is guilty or not.
Incredible.
And absent any other questions, if Ms. Differ wants to add anything with regard to discovery, I think the court pleases on that issue.
I think this was supposed to be a Richardson hearing, so I'm going to address the prongs of Richardson. Whether there was a discovery violation. In their motion, they alleged that the state failed to disclose that Ms. Jensen made statements, but that they were quote unquote a joke or made in jest. or that they weren't serious, or that they weren't an actual intention of these women to conspire to murder anybody. Defense counsel, in state's original discovery demand dated, I think, November 13th, 2023, the state disclosed a number of recorded interviews, a number of Ms. Jensen's statements, and Ms. Jensen's, the content of her text messages with Ms. Gardner, which were presented at the Arthur hearing, including a recorded interview with the Jacksonville Beach Police Department from Ms. Jensen, May 6, 2022. In that interview, she did fail to disclose to police that there were any sort of statements by either of the defendants as the ones that were actually discovered once we did a search warrant of her cell phone and once we brought her to grand jury. In a February 3rd, 2023 recorded interview with Jacksonville Beach Police, which was disclosed to defense on our initial demand, Ms. Jensen at some point during that interview tells police that she remembered Shanna Gardner saying 8 years ago, "I wish someone could shut him up," referring to Jared Brightigan, and that Ms. Jensen then spent some time telling the police that everyone who goes through an angry, bitter divorce say things that are not necessarily what you mean. She tells a story about her sister also making comments, as she reiterated here today, the same type of testimony she gave about the lunch bunch, and how people say things about their husbands all the time. So the defense has been in receipt of both of her prior recorded interviews in which she discusses the animosity between Shanna Gardner and Jared Brightigan, and which Ms. Jensen at both these interviews that are recorded, that have been in possession of defense counsel, does say the exact thing she said today, which is everybody who goes through a bitter divorce says things. They're not serious. They are made in jest. They are made out of anger. We were venting, et cetera, et cetera. So the defense has had this information that is her view or how she's skewing these communications with her best friend. I'm sure once she saw the Arthur hearing and heard the word co-conspirator be using with her name, that's probably the basis for the outrage defense counsel is speaking about. In our exhibit to our response, I attached an email between Mr. Carodi and myself, which CC'd all of defense counsel for Ms. Gardner, in which Mr. Carodi says, following up on our conversation yesterday, meaning with myself, I'm going to seek to unseal Ms. Jensen's grand jury testimony and their actual motion to unseal, which references that they were clued in to do so, so to speak, I'm paraphrasing, by the state. So Mr. Baez's motion, he had said that through due diligence of defense counsel alone, they discovered this grand jury transcript, which had all these statements that the state had not otherwise disclosed. But the fact is that Mr. Carodi called me after receiving the state's discovery exhibit specifically to have a conversation about Ms. Jensen's statements, during which I advised him he should seek to unseal the grand jury transcript. And I specifically told him I did not believe it to be Brady because it was not exonerating. But it has been known to all sides because Ms. Jensen and Ms. Gardner were very close. And as Detective Johns testified during the bond hearing, when Ms. Jensen received her subpoena for the grand jury, the first—
You had the word wrong. That's so funny. She said exonerating. She meant exculpatory. Don't worry, I'll fix it for you, sweetheart.
phone call she made was to Hank Cox, Ms. Gardner's attorney at the time. And then while she was at the grand jury speaking to Mr. Mizrahi and I in the side room after her testimony, that she was receiving calls from Ms. Gardner over and over and over and over while we sat with her. So they've known about Ms. Jensen's statements. They've had her listed as a witness. They've had her interviews and her grand jury transcript in which she makes multiple statements that old comments about taking care of Jared Brightigan or getting rid of Jared Brightigan or statements about animosity or what they would like to see happen to them were made out of anger, made out of like venting, out of resentment and in jest. Those statements are all included in her grand jury transcript, which defense counsel received in January of 2024 after the state of Florida told Mr. Carodi in a phone call, which is corroborated by his email and their own motion to unseal that transcript. So I know we brought that up in our written motion, but none of this is new. Kim Jensen is closely associated with Ms. Shanna Gardner and with her defense team during the entire pendency of the investigation in this case. I disclosed jail calls of Ms. Gardner herself to her defense counsel, in which she's speaking with members of her family about how she said these things, but she never meant them not really. So this defense theory has been known to the defendant, her best friend, her prior counsel, and counsel the entire time this investigation and case has been ongoing. My argument being there has been no discovery violation. There has been no Brady violation. The fact that a co-conspirator says, I'm not guilty of conspiracy is not Brady, is a self-serving statement that is disputed by the context of these text messages and the rest of the evidence that was presented at the Brady hearing. And it's ultimately, I can say I believe the evidence says one thing, they can say we believe it says another. Ms. Jensen can say I'm not guilty of conspiracy. Ms. Gardner can enter a plea of not guilty. It is to the finder of fact, the court in this case, ultimately the jury, previously the grand jury, as to what weight they give all of those arguments. Defense counsel stated that Detective Johns made several affirmative lies on the record and said that I solicited, basically knowingly solicited false statements and made false arguments to the court. That again is simply not true. The statements about the truck, they impeached Detective Johns with a cursory statement in his partner's written report, but they have had the recorded interview of that witness, Jeremy Ordway, in which the actual conversation between Detective Lamont and Mr. Ordway on the date of Henry Tenon's arrest is recorded. The actual content of it and whether or not what was said or not said has been disclosed to them since the state's initial discovery demand. So if they want to take a statement from a report that's a summation, the accuracy of what actually was said is reflected in that interview. And Detective Johns knew the content of that interview, even though he did not know what his partner wrote in a report. So when he's testifying, when I'm asking him questions about Mr. Ordway's knowledge of the case, the fact that detectives came to speak to him, and he said that basically he said nobody told him, hey, this truck was used in the murder of Jared Bradigan. That was based on his review of the actual recorded interview with this witness, what the witness was actually told and what the witness actually said. Miss Lee, the texts with Miss Lee were not argued by the state as evidence that this was a solicitation. It was argued to show the very thing which they're arguing, to rebut this argument that Miss Jensen and Miss Gardner were just joking. Because as they're having a conversation about magicians and making things disappear, Miss Jensen reaches out to a friend to ask her, and Mr. Mizrahi read those texts into the record. The court will determine whether or not you believe those texts to be a long-standing joke, or whether based on those texts and at the time that they're being sent between Miss Jensen and Miss Lee, Miss Jensen and Miss Gardner are having a conversation about wanting him gone. I'm not even joking, quote unquote. So that is just a part of the totality of the evidence, that there was testimony at the Arthur hearing that Miss Gardner also spoke about M, quote unquote, H, quote unquote, her ex-boyfriends, a tattoo artist, that Detective John spoke with a friend of hers who said that she told, Miss Gardner told this friend that Mario could find, quote unquote, find 4 guys and make it look like an accident. All this is a totality to show her state of mind and her intent. It is not the state's attempt to take one text messages out of context, call it a solicitation and walk away. We never argued it for that purpose. The purpose was to rebut the argument, which they made because they knew that Miss Jensen was somehow joking about this. It stops being a joke when you're talking about it with your friend and then you start reaching out to other people about it. But the court can make your determination of whether you put weight in my argument that that's what it means, or defense argument that's not what it means. But in no way did I affirmatively mislead this court. The detective affirmatively mislead this court. And his testimony that there was some issue locating Ms. Lee is not untruthful. She did change her address. He and another partner reached out to her to schedule a meeting, and it was supposed to be a local law enforcement agency in the state of Michigan that did that. And it's not grossly inconsistent with what he said, that they had trouble locating her, and then he was seeking help from a colleague to speak with her. He could not remember if a colleague spoke with her or not. And by spoke with her, we all know that he's referring to an actual interview, not merely speaking with someone, hey, I need you to come downtown. I can't, I don't live there anymore. The same thing with Ms. Luchetti, that she's saying, oh, we were willing to speak with him. He's misleading the court. And the court heard testimony that Mr. Thomas from Intrepid Group and Ms. Luchetti refused to speak as in a actual custodial, not custodial, but an actual interview about the facts, rather than just saying, no thanks, call my lawyer. And then lastly, that
Again, just conveniently ignoring.
There was some gross misconduct by myself, or just
conveniently ignoring all the things about ignoring the check, ignoring the part about how Detective Johnson never spoke with Sue, or sorry, about changing her phone number and all that shit, which wasn't true. Anyway, the list goes on.
Detective Johns regarding the financial records. The state of Florida never, ever made the argument that those records were contemporaneous with the checks, as if to say, hey, he transferred it and then he immediately wrote a check from that. Exactly what Mr. Mizrahi said. We put fuller records into evidence. That was part of the slideshow. The date I clearly asked, both myself and Detective Johns clearly said those records from 2021, because the argument was that Mr. Fernandez, and Detective Johns testified it, Mr. Fernandez did what Detective Johns called odd things with the money and was constantly moving money around between accounts, that there were withdrawals from the irrevocable trust fund into that First Choice LLC home rentals account over time consistently prior to the murder. And the important part was those records are important. They don't correspond with the checks. They correspond with Mr. Fernandez's discussions with Henry Tenon, which began in December of 2021, that he was moving the money around, beginning these discussions, and that he promised Henry Tenon, as came out from Detective John's testimony, a sum of money of $150,000, which happened to correspond with the December 2021 Christmas gift from the Gardners to Ms. Gardner and Mr. Fernandez. So I never made any attempt to mislead or state the evidence meant something that did not mean. The records are what they are. And the state also put into evidence, as further proof of her involvement, the filings for the LLC, the yearly filings for 2001 and 2022 from Ms. Gardner. So those records weren't mentioned. I didn't just put in a snippet of 2021 records, say they were from 2022, and try to mislead this court in any way. We put in a multitude of records. We talked about a multitude of financial gifts, transactions, promises, and filings from multiple years. And I have one moment, Your Honor. All of these records, all of these text messages, all of these transcripts, all of these interviews were provided to defense counsel in discovery ahead of this hearing. So in the Richardson aspect, Your Honor, I would ask that you deny the defense motion. There has been no discovery violation. Any information the defense says they are now aware of that they weren't previously aware of, they have had the ability to know about it. They have known about it. None of it is Brady. Ms. Jensen's self-serving, subjective opinions and beliefs are not Brady material. They don't exculpate Ms. Gardner. They're, frankly, half of them are not admissible in front of a jury. Her opinion as to the guilt or innocence of Ms. Gardner is not relevant or admissible to this court or to any finder of fact. And they're not material because the state acknowledged at the bond hearing, we made arguments on this being a joke versus not a joke and what the totality of the evidence suggested. The state said this is a circumstantial case and it is built on all of the evidence. Each individual piece of evidence can be explained away, but it's the totality of it when the court looks at with her motive, with her consciousness of guilt and her behavior after the homicide and after the arrest of Henry Tenon, that this court should look to in determining what weight to give defense arguments that she had no knowledge, that she was joking, that she wasn't serious, and that she wasn't involved. We went through this, we argued it, they had the opportunity to do it, Your Honor considered it in your written order, you wrote about it, and you denied it. So I'm asking Your Honor to find that there has been no discovery violation, there's nothing material and or prejudicial about any of this, and to deny the defense motion.
All right, thank you. Mr. Bias.
Yeah, Judge, I'm shocked.
Mr. Bias, how long?
Huh?
Because we've been going.
No, really brief. I'll wrap it up quick.
Because I'm going to give
I got you.
everybody a break.
Understood.
I'll go on a long time.
I'm just shocked. Not only do they double down on
I know.
false statements,
Yeah.
they make it worse. And I'm gonna be really quick and brief with my bullet points. Number one, all you have to do is that's why I pointed out the timeline. First comes the grand jury, then then she turns over the phone, and then they have the text messages. Then they have this secret meeting, or this unrecorded meeting with a co-conspirator. So there's no way that the grand jury absolves them of their discovery violation for what occurs in the meeting after they have the text messages. It's absurd on its face. Then Mr. Mizrahi, the first thing he gets up here and says, well, this all could have been solved with an email or asking us for the bank records. If they don't have them, they could have emailed us. Well, we did. We sent them an email on May 24th of this year.
It was actually October 9th, 2023, and we sent the same email in May of 2024.
So we're asking them for these bank records and they're still not providing them. And then he's getting up here and he says, well, why didn't you email us? Okay, maybe he just didn't know about that. But then you got the Susan Lee thing. They disclosed her. Yeah, they disclosed her at the 11th hour. The court heard arguments of that. And we were trying to exclude those text messages. And they were, they were coming at us basically arguing to the contrary why they should be admitted. She laid out her reasons for why it should be admitted, and then we have this. Then Mr. Mizrahi gets up here and he starts telling you about text messages between Miss Jensen and Susan Lee, and then the final thing is, and I have to admit this now, he starts reading, but he leaves out. He's basically trying to argue that it's not a joke, and he reads out loud right now before the court. I'm sure her ex knows a few, as a statement from Susan Lee, meaning in reference to finding a hitman. And I apologize, I jumped right to it, but Susan Lee, I'm thinking Thomas, LOL. That's from Kim. Then he isn't a magician, but I'll ask if he knows any. I'm sure he knows a few. This is her saying that her husband knows a few hitmen. Okay, that's absurd on its face. But then, while Mr. Mizrahi is telling you these, reading these text messages into the record, he leaves out the very next one after she says, "I'm sure he knows a few." The next text message is LOL. It's a joke. It's absurd. And in their PowerPoint, Judge, during the hearing, they deleted the LOL. It's not there. I'm looking at the slide right now, and it goes straight to, I'm sure he knows of you, and the next text message is, are you home? If that's not misleading you, I don't know what is. On top of one thing after another. That's why I'm shocked. I can't believe they're doubling down and then making matters worse, reading text messages to you in the record and leaving out LOL to convince you of something completely different and say, no, this is, the court can make a decision based on these conversations. This is unbelievable. Then you've got the bank records. Ms. Stifler gets up here and tells you that she mentioned 2021. No, she did not.
Did
And
not.
I invite the court to read the transcripts
Yeah.
of her questioning Detective Johns, because when this all came up, that's the first thing I did. And it's clear that's what the court believed, because it's in your order. Follow the money.
Yeah.
And the court was under that impression as well.
That's what I said. That's what I said. Had they actually pointed out it was a different year, it would have been like, well, why are you presenting? I mean, yeah. Anyway, wow.
And then when you review the transcripts, you're going to notice, because I noticed this, that they give the dates, but they never give the year. And they're specific about the dates. March 26, excuse me, I don't know the exact date, I don't have it in front of me, but March, and then he goes into the April thing, the April bank records.
So
and it's clear.
this matters because, in other words, they didn't say it's from 2022 or whatever. In other words, they don't give the year, they just ask for the month, so that the year is implied to be the year, because it was within the context of the questioning. It was the context of when the murder happened. And it's just supposed to be implied. That way they can say they have plausible deniability, but that's so misleading and misleading the court, right? I mean,
Clear that they are attempting to mislead you into thinking that this money from the Shanna Gardner Trust went into the bank account, and then it went to pay a check for Tenon, when you know that's absolutely false. And then finally, to talk about the issue with Ordway in the truck, and that we could have used a recording to say what he actually said versus what's in a police report is I think it's a very weak argument at best, because forgive me, I have this crazy thought that a detective is going to get on the stand and tell the truth, that I won't have to impeach him, that I won't have to call him out for being a liar. But according to Ms. Stifler, I need to have voice recordings on the ready just to be able to impeach someone, and to let and for full disclosure purposes, what's in the actual transcripts and what's in the actual recording is, he says Tenon's truck was used in a murder in Jacksonville Beach. That's specifically what was told in that recording. So I don't understand the argument. I don't understand why they would make such a claim, but certainly they certainly don't have the right to leaving out text messages in their, not only in their slides to the court at the Arthur hearing, but right here, right now, in arguing these issues, especially after seeing the court's concerns over what's being presented. So I would submit, I don't know what we have, defense one already?
Up to 4. Is that correct?
Are we up to 4?
Any objection?
You'll know, we're looking at it.
Okay. That'll be marked as defense 4 for the hearing.
I promise I'd be brief. I wasn't. Well, I tried to be. And I'll rest on that rather than give continued argument.
I forgot to update my tutor.
Let me see the lawyers at sidebar.
Sidebar. Wow. There was some text. What was that text?
I'm at y'all's disposal. I have a couple of conflicts, but I'll listen to you all first.
Scheduling?
If the Gardner case wants to come back to sort this issue out, I'm open for that, and I can separate the two defendants. And then we can reconvene after the depositions. Is that the only deposition that you all have, which is what was set today of the minors?
Yes.
That's all we have on the calendar. We did accomplish a lot of zoning cases.
The state's preference is not to separate the defendants. I would assume that we could come back perhaps the last week in September. I'm unavailable that Friday, but I'm available the other parts of the week.
I'm generally available in the first quarter of that week.
Perhaps Monday the 23rd, we could do it before we pick any juries that week. Like 8:30 on Monday the 23rd.
Yes. All right, September 23rd, 8:30 a.m., 406. Pretrial. Both cases.
Thank you.
Thank you.
Almost.
Okay, so that's it for this one. Wow. Well, that was a lot. So yeah, the thing about the checks is really crazy because their whole case hinges on that. And like, what do the banking records show for the months in question? And again, like I said earlier, it just makes you wonder, like, I don't know. It raises a lot of concerns, like I said earlier, about a false confession. I don't know. I mean, the way that was represented with those checks was very not good, to say the least. So yeah, it was long. So I believe, though, that this hearing that we just watched is the longest one of the hearings that have come out since. Yeah, so next time we will, let's see, after this hearing, there's some documents that come out. So that, of course, those will be next. We have 823. So this was from August 16th, right? So then we have 823 and 827. We have court filings from that. And then I believe there's another hearing, but of course I will get all that ready to go for next time. So yes. But yeah, but that's all for this one. I might pop back on later to do some more Koberger tonight. We'll have to kind of see. I have some stuff I have to do for my students, my violin students. But anyway, I've been working on putting together some information regarding the DNA and the IgG because it's all very confusing as to what is going on with that. And it's been an ongoing issue. But we still have to finish the state's objections to the motions to suppress. And then I also have, I think it's already scheduled. I don't remember for which day, but I have the next episode for Casey Anthony scheduled as well. I think I already have stuff scheduled for every day this week, but subject to moving it around, especially because I don't think I have anything for tonight. So if I move anything tonight, then that will happen. But that's it for this one. So guys, thanks for watching. We appreciate you, Flashman, for always being here and also contributing to the chat. Have fun modding on all your different channels. But yeah, I love y'all. Thanks for watching, and I'll see y'all next time.